Lord, may I be permitted to mention one matter from your Lordship's list, my Lord Justice Arindam Mukherjee. Urgency is that it is running in the list. My Lord, urgency is that my Lord, the recruitment process initiated 2022. My Lord, we are the successful candidate. There was no merit list published by the SSC. My Lord, the 36 by the SSC, Staff Selection Commission. That was the indication in the notification itself. The merit list should be published. What they do, they do the cut-off marks set up for the medical test done. Thereafter, again, they have set up the cut-off marks without publishing the merit list. We have challenged that. Another point is that 3,600 candidates who have used the fake domicile and they have indicated we are just below 0.25, 0.5 marks below the cutoff marks. If the 36 urgency is that they are going to fill up the adjust the vacancy to the 2015 matter. It was filed in 23 after just publishing the matter.
Sorry.
That was hard and
sorry.
There was a direction for filing the report with regard to the merit list.
No, you appear move the regular benches. Any other mentioning? Group 2. Group 2, this is not a date for mentioning unless it is extremely urgent.
My Lord, may I have your kind leave to mention for Group 6 matters, my Lord, just on the Mukherjee determination. These matters are regarding constable post for CRPF and Assam Rifles. They have rejected these petitioners only on the ground of height. Although they have the height on the previous years, they were the requisite height is 170 centimeters. In the previous years, the medical documents from government hospital shows that they have the height of 170 centimeters, but they rejected them for 2 millimeters or 3 millimeters, which is below 0.5 millimeters. There is also Supreme Court
already rejected.
They rejected that.
What is the urgency?
Urgency is that on the 8th, this entire proceedings will complete on 8th of November. And
what proceedings?
The medical and the physical test. The PS.
You could not appear before the interview.
My Lord, there is
you could not participate in the selection process.
I have participated.
Then your eligibility was not considered. You are found not eligible on the parameter of height.
2 millimeters or 3 millimeters. But on the same center, on the previous year, we have success. We had succeeded in previous year having the height of...
on 8, what will be done?
8 will be, this entire proceedings will complete, and then the results will come on from 9th to 21st of November. They will start compiling all the successful candidate and then publish that to the submit that to the SSC.
Well, leave granted, serve notice.
Tomorrow top, my Lord.
It will appear on
tomorrow top, extremely urgent, my Lord.
7th.
I'm mentioning one extreme urgent.
But you have to ensure that the presence of other side.
I will, sir.
Yes.
Regarding item 844, my Lord.
Today is not the date. Sorry.
My Lord, urgency is my Lord.
Sorry, is not the date.
My Lord, may I be permitted to mention, my Lord, a Group 6 matter, my Lord. My Lord, the difficulty, my Lord, the urgency is that, my Lord, this is a matter of, my Lord, the Life Insurance Corporation. My Lord, 2 of the rules of life insurance corporations have been challenged, my Lord. The virus have been challenged in, my Lord, numerous writ petitions. Now, my Lord, while, my Lord, the matter is, my Lord, sub judice in various writ petitions, my Lord, they are continuing, my Lord, issuing, my Lord, notices of termination under that rule. Now, my Lord, in previous, my Lord, numerous writ petitions were filed, my Lord, all have been stayed, my Lord. Again, my Lord, my client, my Lord, has been served a notice.
What is the urgency? It's a matter relating to challenging virus.
Virus, my Lord, termination notice has been, my Lord, served on 18th of, my Lord, October. Now, my Lord, yesterday it was affirmed, my Lord, the period, my Lord, after which it will be affected is for 30 days. Therefore, my Lord, on 18th of this month, my Lord, this will be affected.
Yes. So I have determination up to 14th.
My Lord, my Lord, I'm only left with 2 days because, my Lord, the Lordship is coming back on 17th, my Lord.
Leave granted Monday.
Under
the heading motion Group 6.
Grateful.
Mentioning for upgradation of.
This is not a date for mentioning of regular matters. Since it's a special determination, that's why I'm entertaining.
No,
yesterday, I allowed everybody to mention the matter. Don't take advantage. Item number 1.
Yes, please, my Lord. My Lord, this is that matter, my Lord, pertaining to St. Augustine's Day School, my Lord. My Lord, please, my Lord, to appoint.
Just a minute.
এসে গেছে আছে কি না কেটে গেছে কি করে টাইপে প্রিন্ট আউট স্পেসিফিক লিগেল ফ্যাক্ট কিছু হয় না কনসিডারিং তিন লাইন নেই কেন বড় কি বলতে পারে এটা চলছে তাই বেঁচে গেছে
Yes, your report. You completed the process, entire formalities. How many students have been found to be bona fide students to participate in 2025 examination?
Your Lordship passed regarding 140 students. But there is a practically there is a 283 students. 283
Students.
because there is two other
Who
sections.
are not petitioners. 145 had only approached the court.
Yes, that is recorded in the.
I have special officer is correct
made a
that
report,
there
I
are
have made a report regarding
total-
145 students. And this is the attendance registered at all sections. And there are other and mark sheet and others no, this outside the code mirror, there be a big volume yes, no, this result of
there is one aspect of the matter Manoj, which needs to be apprised to your
Just a minute.
আগের দিন ছিলেন না তো দরকার হলে দাও
পরে মনে হলো যে ব্যাপারটা ছিল
In some places, there are typographical mistakes that come to page 4 of your report. Second, after the continuing paragraph, at the middle, class 9, class 10 and class 10. Similar mistake happened. Page 5, first line. Yes,
There is only one issue on it.
you are representing the school authority. Yes, I will hear you. Yes. Then what would be done, because there are it is as per report of the special officer that there are 144 students out of 145 petitioners, because one has taken transfer, and 83 students are there who have not approached this court, And according to the special officer, they are also bona fide students. Yes.
Now, my lord,
So what is your proposal?
May I just see the
What-
report,
what
my
is-
lord?
Yes, go through the report.
But maybe I'll also have.
Yes, yes. Supply the report to the learned advocates representing all the parties.
now, my lord, there is.
Yes, Mr. Sen.
Now, only one thing, my lord, this registration issue of the students, your lordship is taking care of. Now, the one issue which is interlinked with this registration issue is they will be registered for sitting in the exam through my school. And that is where,
Well, because that is not possible since your school's fate is hanging in the balance
no, now,
in connection with the writ petition which is pending before the coordinate bench.
no,
And a similar order was passed by the coordinate bench in the previous session.
no, but now kindly.
So therefore, I would follow the same thing. You get an order from the court,
No,
have
that is my submission, my lord.
have the order of derecognition be set aside. And pass and then you will be permitted to take all steps.
May I say this?
At this stage, if I pass an order in deviation of the order passed by the coordinated
But
bench
I
in
am
the
not
previous
saying-
year,
but I am not saying
that
so.
would not be a proper stand so far this court is
I am
concerned.
not saying so. My lord, what I am submitting before your lordship is that specifically because of this fact that this problem will arise, the other matter was mentioned on out of turn basis and taken up by the learned judge.
Yes,
And your lordship will kindly see this order now. It has been kept 1 week after vacation.
yes,
Now the determination is before your lordship
yes.
in this matter. So my humble submission before your lordship is that kindly take both these matters together.
Not possible. It's not possible. Let the fate of the students or the academic future of the students be saved.
No,
And
it is absolutely safe.
then legal battle
No, it is
would
not,
be
my lord.
permitted to continue. And whether this order of derecognition was rightly or
We are not-
disaffiliation has been rightly passed or wrongly passed, that is to be considered.
My lord, kindly.
But these two things should not be interlinked. I had the determination prior to that. Who has mentioned this matter, Mr. Sen?
I did mention, my lord.
Yes,
Yes, I
yes,
mentioned.
but today, considering my list, it's not possible. Don't take the advantage of having your or getting your writ petition disposed of at the time when the academic interest of the students of class 10 is at stake.
My lord, it is
That
not-
I would not,
No,
I would
am-
not permit.
we are not jeopardizing the interest of the academic.
Yes, your matter will be considered in
Then-
accordance with
then,
law.
Then, my lord, what happens? Kindly see what happens and kindly see this order.
When this disaffiliation order was passed,
The matter has been pending.
when this disaffiliation order was passed,
Passed in 22.
then
And
in
we have challenged-
2023, similar order was passed.
No, my lord, at that.
So therefore, don't mix up
It is not-
the examination issue with your disaffiliation
It's
issue.
not a question of mixing up. Here, my lord, kindly what happens if my matter is not taken up at all, then what happens? The school becomes closed. Because that time last year, the order was passed considering the plight of the student that the examination was 2 months, 3 months away. That is why,
Same thing happened.
No.
Today we're in the month of November.
yes.
Examination will happen in the month of February
February,
2025.
February or March,
So
my
but that eventualities have also been protected by the last order.
Don't try to take advantage of the
This is not
situation
under which
when the academic career of the students
we are
are at
not
stake.
taking advantage.
No, that will be considered independently. If this court has determination, court will consider it. And whether the bench where this matter was running, this court does not have determination. Then
No, but kindly, it is not this.
Justice Chattopadhyay does not have determination. Today.
Now, at present, he does not have. my lord. Otherwise, my lord, this matter.
Well, that will be considered. But I am not going to mix up these two issues. Sorry.
But your lordship will kindly list my matter. That is
Yes,
my-
yes. That if the Justice Chattopadhyay, if you submit, Mr. Sen, that Justice Chattopadhyay does not have determination,
does not have.
then I will direct that matter to be listed under the heading
here.
hearing.
After vacation, my lord, the determination has changed with regard to.
There is no
hearing
other bench having determination to take up group
Well,
2 hearing
well,
matters.
The learned judges are in the division bench.
Please check up the list.
I am told, my
Some
lord,
finite
Dekhi,
bench.
comment.
it is with Justice Hiranmoy Bhattacharya and Justice Gaurang Kant.
Two benches are not
And
regular
those
bench,
benches are not available.
not regular bench.
Yes, not regular bench. And that matter also, my lord, it is not being considered on merits. Your lordship has seen the order. The board has been directed to conduct an inspection and to find out about the new building. And to pass an order that the matter is to come only for their order. But it is the plight of the students which we are espousing. 1 year I could have understood, my lord, there was no affiliation, there was no time the students, we had consented, yes, let them appear through a different school. If the school suffers, the students suffer, my lord.
Your matter is 2023 matter.
Yes.
Yes, after vacation up to 2021 determination is good. Well, I will accommodate your matter in the list. But
But
don't stand in the way
kindly,
in the matter of completing the formality, Mr. Sen, relating to
the
registration.
exam is in February.
No,
I
no.
am only
I will not permit this, that keeping the academic interest of the students hanging in the balance, you will try to get your writ petition heard. That practice I will not
I am
support.
trying to get my writ petition heard for
Yes,
the
yes.
students.
There is
For
no,
the students
yes,
itself.
there is no fault so far your approach is concerned. But don't mix up these two
No, I am
matters.
mixing up,
Yes.
but kindly see.
Permit this court to pass an order to complete the formalities relating to registration so that they can appear in the final examination of 2025 in the month of February
But
2025.
kindly only one.
But at the same time, you are absolutely correct that your writ petition needs to be heard. Now, today the position of this court is so far it's a motion bench basically.
But it is
Up till now, I am telling you, I have not been able to touch any hearing matter.
no, but it is not like a hearing matter. If your lordship,
Any hearing matter.
Your
So
lordship
therefore,
sees the-
it's a disaffiliation matter. It will take some time.
no, your lordship.
You are saying that within 10 minutes matter can be disposed of. That is not the fact.
Because
Because-
this is the last order.
Yes. So therefore, this court has to hear it from the very beginning.
No, my lord.
So it will take some time.
But
I should not draw up a picture in front of the learned councils representing the parties today that by within seconds this 2023 petition can be disposed of. If you pray, I can include your matter in the list under the heading in view of the situation which is continuing. And it also, you are absolutely correct, it also touches upon the academic career of the students who are prosecuting their studies in the school. But that does not mean that the present writ petition should be kept pending till your writ petition is heard.
But
How that can be supported?
no, I am telling your lordship, my submission, my lord. Kindly see the other matter. The order is only very limited. It is not with regard, that order has not been passed on hearing of the merits of the matter. Your lordship today for the timing is only required to consider the effect of that order, whether they have inspected, report has been given, and what is the result of that report.
Yes, result of the
So if
report.
suppose the result
report-
is positive.
Report is called for only to complete the formality of registration, nothing
My
else.
lord, not one. I am talking about our matter. Your lordship sees justice.
That I will consider. When it will be heard, I will
So
consider
it
it.
is not to be heard
But-
on merits.
But
Today, it is not.
it's a disaffiliation matter.
My
It
lord,
has to be heard on merit.
may I- একটু দাঁড়াও।
It has to be heard on merit.
But-
Because at the end of the day, the legality and validity of the disaffiliation order has to be considered, whether it is rightly passed or wrongly passed.
But-
I'm not saying that I will not include your matter in the list. But this court cannot give words that on a particular date matter will be concluded.
But if your lordship,
So, therefore,
is
you have, Mr. Sen, you have got a platform to make your prayer for early hearing of your writ petition, which is pertaining to disaffiliation of your school. But that should not stand in the way relating to completion of formalities of registration of the students who are studying in class 10.
but if this situation was in January or
Because
February,
they
I
are,
would not have
because,
made this
because
submission.
you have to consider in a broader aspect that they are your students. They are your students.
On the last
So
year-
don't, Mr. Sen, since you are there, don't stand in the way.
But I am not standing. Kindly do not
Yes.
misunderstand. I am not standing.
No, I'm not misunderstanding you.
No, it's
I
not-
know you are a very reasonable person.
No, no. Why?
And
why?
when, especially when the students' academic fate are at stake,
Yes.
so therefore, this court
Disaffiliation.
will pass an order following the order which was passed in the previous year by coordinate bench, and
But
your
that
writ petition
that
will be
situation
directed
will
to
cause
appear in the
prejudice.
list for hearing.
But that situation will in fact cause prejudice and make our writ petition
How?
infructuous.
It's a
Because
there will be an observation in the order which is to be passed by this court, that without prejudice to the rights and contentions of the
it is not
parties.
a question without prejudice.
Without
Today-
prejudice to the rights, and this order is passed under the special
But
circumstances.
today they will be registered and
Yes,
as
sure.
examinees of which school? That is the question, my lord.
Mr. Borua, whether these 83 students are the bona fide students of the school?
Because I have not taken any answer sheet because there is specific direction upon the 145 students. So my lord, I didn't ask if this person will produce their mark sheet. Because a specific order was there for 145 students.
I think, my lord, your lordship's order was for all.
No.
No, it was with regard to
No, no,
one forty-five.
the order.
They got 145 students. Your lordship, your lordship's order.
Kindly see, on consideration of the documents which shall be submitted before the special officer on 22nd October, special officer shall prepare a report containing names of
Which page of my order?
page 3, first paragraph, last sentence on consideration. Special officer shall prepare a report containing names of bona fide students who are studying in the said school. It is not restricted to only 142. Writ petitioner.
Lordship, can you see? There is specific. Is in respect of the 145 page, my lord. Page.
Yes, I have mentioned 145 students.
Page 2,
Lordship,
my lord.
paragraph 2 at
Paragraph
Lordship's,
2, page 2.
page 2 of your Lordship's order.
145 writ petitioners claiming to be a students of class 10.
Yes, that is
of the
there,
said
but
school. Though they are graduate, though they are
final binding is
guardians have approached this court with their present writ petitions and
But
in
Lordships
support
can
of their
always mold the
content.
relief.
For that reason, I have stated last paragraph, my lord, the case of 183, only 83 students may be considered.
Since these students have not approached this court, they should not be left out.
If Lordship sees your Lordship's order, last page, my Lord, first paragraph, last 4 lines, Lordship, on consideration of the documents which shall be
Yes,
submitted.
that is what Mr. Sen has also pointed out.
So, my Lord, Lordships can always mold relief, my Lord. My Lord, other students who have not approached, my Lord, Lordship, possibly they should
What
not
you have
suffer.
stated in your report, Bosho, with regard to this one.
Last paragraph, therefore I stated.
May be considered.
And given so the remaining 83 students of the class 10
May be considered.
Whether they appeared before you.
Because, my lord, I am reluctant to take their answer because, my lord, they issued such order because they are not the repetition. The specific direction upon only on 45 students.
Then let a further
Amongst them, you have indicated that 27 or 25 students are coming from economically
They are in
weaker
the
sections.
meeting and 7 my lord, the unprivileged students were there. And
In section F,
section G and F, both.
there are 7 sections in class 10.
Yes, 7 section G and F. Privileged classes is section G. And my lord. F, sorry, it's a privilege section F, and that is G. Section G is economically backward classes.
Mr. Sen, in your school, whether there were 7 sections in class 10,
no, only South
could not
Point
be.
in our time.
we could not imagine.
Only in South
That
Point.
is the
I remember.
difficult, you know. I have also marked it. There are 7 sections in class 10, 5 sections in general sections in class 9.
Oh, my lord, there is one particular section for special needs children. Only 5 children are there.
Underprivileged students with disability.
No, sir.
Huh?
Both are different.
Yes.
Underprivileged is
Underprivileged.
separate.
Oh, these are underprivileged students.
Section G.
Section F, there are 5 students underprivileged.
No, sir. They are
Special needs.
special.
5 is
Special needs.
disabled.
They are not differently able.
They are different.
Yes, that is what I am saying.
Hello.
The students with disability. Now, Supreme Court is saying don't use the term specially able. The court should use the term the candidates with disability. So there are 5 students, whether they are the petitioners.
No, my lord.
They are not the
They are
petitioners.
not the petitioners, my lord.
And what about these 25 students reading in class? They are not the petitioners. They are coming from economically weaker section of the society.
But I have prepared a
So therefore 25 plus 5, 30 students are there who are not the petitioners. But apart from that, 83 minus 30,
And remaining total is 28.
53 students are there who are not coming, who do not belong to the category of students of section F and section G, but they are not the petitioners.
They are not repeated. And my lord, you will see in the report, next report, my lord, who are the petitioner and who are not the petitioner, I have clearly stated in the report. Your lordship, can you see? See the report, my lord. And section A, and this is right side, my lord, number of the petitioners.
Mr. Baid, what is your stand with regard to these 83 students?
Well, all bona fide students, well, humbly submit, should be allowed to take it. The question is that is perhaps, for the sake of formality, required to be tested. These bona fide students, my lord, of course they will be. And in the meantime, my lord, I shall forward the report to the council and whatever they, my lord, instructions I get.
No. But regarding 83 students, whether they should be left out?
No, my lord, that's exactly what I'm submitting. What I'm saying is, they
Then
should
who
not be.
determine that
But they
they are
should
the
not
bona
be.
fide students or
My
not?
lord, I'm saying they should not be, but the learned special officer should at least test the bona fides, whether these are.
Let the special officer come once more. We will
May I just-
produce the
may I
documents of
just
these
finish?
83 persons. 83 students.
So for the time being, my lord, I shall forward the report. And my lord, if I want,
No, for the timing, I will direct that to complete the formalities of this 44 students, complete the formalities relating to registration
my lord, initiate,
for
my
their
lord, it will take some
appearance,
time.
for their participation in 2025 examination.
We will initiate, it's going to take some time, my lord.
How much time would be required?
Because coordinator has to be appointed and the students have to go there, register, but it will be all done. It will be all done, I assure your lordship. we will take steps to register these students. Lordship will kindly order that, and we will.
So that
apply
they
for-
can appear in the examination
lord.
through different school.
Yes, my lord, we will, because those schools have to be approached, identified, how many they can, different subjects are there, whether those schools have those subjects. So those students will be identified, but we will,
That will.
So if
create-
I grant a fortnight time,
well, it won't happen. But then when I assure your lordship, this will be done. Lordship will kindly take
no,
my word. it will be
indicate
done.
the time period within which time it is to be completed.
Well, I'll have to take instructions because it's going to take 1.5 months. So by January, they will all know, they will get
Yeah.
their cards.
Completed within 30 days.
Well, perhaps
Not
Lordship,
beyond.
well,
It's not
I tell your lordship, it's not only dependent on
Because all the schools which are Anglo-Indian schools, Christian minority and Indian schools, those will be closed in the month of December.
No, my lord, this work will go on. The only problem is, my lord, identifying, and the schools agree, because it has to be in and around that area. I can't just spread them far off in the
Anyway,
fringes.
take 30 days
So,
time
my
and
lord,
try to complete.
lordship will kindly not tie my hands, my lord. Lordship will say,
And in
preferably
the
within-
meantime, you visit the school once again for 83 students and find out their bona fide and submit a further report. Then if necessary, a separate order is to be passed for this 83
Yes, my lord, that
students.
can be done. And my lord, we'll endeavor to finish it in 30 days. Lordship
Yes.
will,
Well, then it should be done for the class 12 students also, since
I
my
don't know. What is the
the
no?
special officer is.
So they are not before me, I will not consider.
It's a student's interest. When your
I don't-
lordship is
No,
looking at this-
unless and until I am considering a writ petition of class 10 students. How that is possible?
Otherwise, the board.
How this court can go beyond the ambit of the prayer? There are difficulties, technical difficulties are there. All the students are
Since-
reading in class 10.
Very well, but I see, but I am interested in a dual interest. One is for.
No, I appreciate your stand. You must express your anxiety with regard to the fate of the school. Absolutely correct.
Yes.
Absolutely
Otherwise,
correct.
kindly see,
Otherwise, how long this interim measure can continue?
this is a ploy. And in my writ petition, I say that this act of disaffiliation and continuing it is a ploy so that year after year, they are
It will
registered to different.
No, that should not be.
But
That
the
this
school
court
is actually obligated.
that this court cannot support. You are absolutely correct.
I
That
am
you
very sorry to
you have
say
got
that is what has happened.
got an opportunity at least. Yes, I remember you mentioned this matter. Since I was not entertaining mentioning of hearing matters, I could not allow your mentioning. None of the not a single matter was included in the list. But at the same time, the fate of the of the school and the anxiety of the school authority can be ventilated before this court at the time of hearing during the course of hearing of this writ petition. There is nothing wrong in it.
But these
But-
have, my lord, only one submission, my lord. If your lordship sees the last order, it is not on the merits of the affiliation. It is only saying that there is a change circumstance. School has got a new building. They will now inspect the new building and give a report so that a order can be passed. Now, the court has kept the matter to see what is the order they are passing with regard.
Not part of matter.
Not a part of matter. My lord. No, but so therefore, as your lordship felt that your lordship will have to go into the merits of the affiliation order, probably that is not required.
Very well. I will include your matter in the list and I will try to take it up.
Kindly keep
But-
it as a motion because it is a
but-
short
but-
report.
But the situation is today, the purpose of taking up this matter is completely different. You should also appreciate this.
I would definitely appreciate.
Because
but,
they are your students.
but your lordship will also.
They are your students.
Yes, but your lordship will also kindly appreciate that board is taking advantage of this so that they are registered through a different school. Kindly keep the matter only for consideration and placing of the report by the board.
Only, my lord, petition number 120, possibly, my lord, his name may be omitted, my lord.
Why?
My lord, he is the
He has
one who
taken transfer. It's not necessary at all. I will not permit him because he has taken transfer. Question of permitting him does not arise at all. Yes. In terms of the order dated 7th October 2024, Special Officer visited the school on 22nd October 2024 and verified the documents of the words of petitioners, guardians of the petitioners, of the words of petitioners. Stop. It is also indicated in the report which is filed today and taken on record
My lord will kindly,
by the special officer
my lord will pardon me, my lord,
that out of 145 students whose guardians are the petitioners in the present writ petition, one student has taken transfer and rest 144 students who are presently studying in class 10 of the school are bona fide students. Stop. Next paragraph. Matter is heard at length in presence of the learned advocates representing the petitioners, council. Now, Indian schools council for the Indian school certificate examination, council 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 for the Indian school certificate examination, within bracket for short council, close bracket, council quote unquote, and the school authorities of St. Augustine's Day School. Stop. Special officer, no, stop. Mr. Himatri Borua, learned advocate of this court, being the special officer, is also present in court. Stop. Next paragraph. Mr. Sakko Sen, learned counsel representing the school authority, submits that a writ petition being WPA 23857 of 2023, within bracket St. Augustine's Day School and another versus Council for Indian School Certificate Examination and others, close bracket, is pending for adjudication, wherein disaffiliation order issued by the council, CETA capital by the council, is under challenge. Stop. On behalf of the school authority, it is further submitted that there is a need of expeditious hearing of the said writ petition for the academic interest of the school as well as the students who are prosecuting their studies in the said school. And if the issue is decided, and the issue involved in this, and the issue involved in that writ petition is decided, there would be no further necessity to pass separate orders in order to ensure participation of the students of class 10 to class 10 in Indian Certificate of Secondary Education Indian Certificate of Secondary Education Examination 2020, Indian Certificate of Secondary Education Examination in each year. Stop. It is further submitted that though the writ petition was being heard by a coordinate bench, but at present, this court is having determination to hear the writ petition. To hear the said writ petition. And prayer is made for enlisting the writ petition before this court for early disposal.
The direction was under to be mentioned, it will appear.
Stop.
Only to consider the report,
Stop.
not for final hearing.
Next paragraph. Having considered the submission made on behalf of the school authority, this court finds that the pending writ petition being WPA 23857 of 2023 needs to be heard, and exceeding the prayer made on and exceeding the request made on behalf of the said school authority, this court directs the writ petition to be listed under the heading hearing in the monthly combined list of December 2024. Stop. Next paragraph. However, academic interest of the students, academic interest of the students, guardians of whom have approached this court with the present writ petition needs to be protected, taking note of the contents of the report of the special officer which is filed today. Since it has been stated in the report of the special officer that 144 students, now in the writ special officer, that there are 144 bona fide students out of 145 whose guardians have approached this court with the present writ petition, the concerned authorities of the council is directed to take necessary steps for completing the formalities and relating to registration of these 144 students and make an arrangement so that these students can participate in Indian Certificate of Secondary Education Examination 2025 through other neighboring schools which are affiliated to the council. The council is directed to complete the process of registration by 30 days, complete the process of registration as expeditiously as possible, preferably within a period of 30 days from date. Next paragraph.
One thing, upon their complying with formalities, because payments have to be made. The registration.
Yes, the guardians is on compliance of formalities includes that they, unless until the fees and other payments are made, how can it kind? How that can be? Acha. Last sentence ki bola. Stop. It needs to be recorded that the guardians of the students, guardians as well as students, are required to cooperate with the council to complete the process. Next paragraph. This court cannot shut its eyes to the other aspects, which also appears from the report of the special officer filed today. Stop. Apart from 144 students, there are 83 students who are also studying in class 10 in the said school, in the school in question. Stop. The report of the special officer also suggests that in section F of class 10, there are 5 students with disabilities,
Yes.
And in section G of class 10, there are 25 students who come from economically weaker section of the society. Apart from these 30 students, there are 53 students who are also studying in class 10, guardians of whom have not approached this court for the registration of those students. Stop. Since the court has passed order directing the council to complete the formality to complete the registration process, in respect of 144 students. Similar order needs to be passed in respect of other 83 students of class 10 of the said school, subject to verification of their documents, which has not been done by the special officer, since to that extent there was no specific order passed by this court on 7th October 2024. Stop. Next paragraph. Mr. Sen, learned counsel representing the school authority, has submitted that similar order be passed as it was passed on 7th October 2024 in connection with 83 students, to find out whether these students are bona fide whether these candidates are bona fide students of class 10 of the said school or not. Stop. This court appreciates the stand taken on behalf of the school authority for the sake of those students who have been left out. Stop. Next paragraph. Having considered the report submitted by the special officer as well as the submission made on behalf of the said school authority and the learned advocates representing the petition, representing other respondents, this court direct Mr. Himadri Borua, special officer, to visit the school once again on
7 days, that is the 14 to 21, I will be not here. So apart from that, the 8 to 23.
So you visit on 11. School is there, they will inform the students.
Saturday.
No. Monday. You visit on 11 and submit a report on 12.
Monday court open. For that is a nice thing.
Do for the students. Or on Saturday.
Saturday, yes. Saturday.
But you are not there from 14th.
14 to this fast Saturday.
Today is 5th.
7th, 8th.
Today is 5th. Then you during which period you will not be available?
From 14 to 23. On 9th, I can get.
Just a minute.
Students will not be there.
14 to 20, 14 to 23.
Then we'll have, yes, we'll have.
Let it be on 11th. Visit the school on 11th November 2024 and inspect the documents to be produced by those 83 students and submit a further report before this court on 13th November 2024.
13th?
November 2024. 13th, 11th and 13th November 2024, when this matter will appear under the same heading at the top.
13th November.
Stop. Next paragraph. Since school is represented by learned advocate, since the school in question is represented by the learned advocate, comma, the school authority is directed to communicate to inform those 83 students to enable them to appear to remain present on 11th November 2024 at 12 noon, when the special officer will visit the school. No separate notice is required to be served upon those students. Stop. Next paragraph. Since this court has passed direction upon the council to complete registration of 144 students, it needs to be recorded that this order is passed without prejudice to the rights and contentions of the parties in connection with the pending writ petition being WPA 23857 of 2023 within bracket St. Augustine's Day School and another versus Council for Indian School Certificate Examination and others, wherein disaffiliation memo issued by the council has been put under challenge.
The order of 6th of September.
Yes.
6th September order. Our writ petition.
Yes.
The second page.
Yes.
The first page, 73. That inspection take place on scheduled dates. Inspection report shall be placed before the executive council of the council within a period of 1 week. Thereafter, executive committee shall consider the report and pass necessary orders regarding affiliation within the 1 month thereafter. That has expired on 27th of October. Thereafter, in workshop is trying to be page 2.
Very well. Mr. Sen, let this matter be included under the heading hearing. Then you renew. Then renew your prayer. I will consider.
But this is directed to appear 1 week after under the heading to be mentioned because of the report.
You know, so far hearing matters are concerned. If this court would have been exclusively a hearing bench, then question would have been different. Very well, I will consider your case. Let it appear under the heading December. You renew your prayer. Let me consider it.
Very sorry to renew my prayer. Kindly keep it as to be mentioned in terms of.
That is the usual order which this court passes. Let this matter be accommodated in the list. Let the a combined list of for the month of December be published, and then you renew your prayer. I will try to accommodate you.
Yes, but let them the report is
Let us.
This order has to be complied with.
Yes, next one. এটা এর মধ্যে ঢুকিয়ে রেখে দাও। আইটেম নাম্বার 2 ওটা আগের দিনে অর্ডারটা দেখে নিও কি রকম। আচ্ছা ওই স্পেশাল অফিসার ইয়েটা ওর মধ্যে
Item number 2, my lord, I could not effect service. I was only praying for a week's accommodation. I will effect service and come back, my lord.
Then you'll miss the bus. What can we do? You will miss the bus. What you are praying for?
My lord, I'm praying for the release of the interest amount for a delayed payment of the arrear amounts. This is the prayer, my lord.
This matter can wait. Issue. At the time of call, learned advocate representing the petitioner has prayed for accommodation to complete service of notice upon the respondents. Next paragraph. List the matter under the heading motion in the monthly combined list of December 2024 in order to enable the learned advocate for the petitioner to complete service and file affidavit of service.
I'm grateful.
Next.
Item number 3.
Your lawsuit need not go into matter. Kindly hear me 2 minutes time.
Yes.
Now here
Yes.
the private respondents was appointed.
Whether all parties are present.
The copy have been served.
State. Yes, who is appearing for the state? Whether state's presence is required? Not required. Yes.
Let me this.
But I have, on the basis of the complaint lodged by me, everything has been.
Who are you?
Lord, I am the
Now let me
teacher.
make my submission.
Who are you?
Lord, I was appointed as a teacher.
So you are a teacher of the school.
Yes.
You complained, you made a complaint, lodged a complaint against the teacher in charge. Board has. Yes, yes, Mr. Dotto.
Yes. Now the private respondent was appointed as a part-time vocational teacher. Now, my lord, the allegation against that private respondent is that he.
What is the scope of interference? So
No,
first,
let me make
for this concern.
No, I will satisfy to lordship. I will satisfy.
No, you are, it appears to me prima facie that you are trying to place the case in a bigger campus.
No, I'm not.
That I will not.
No, I'm not. I will take 5 minutes time.
Yes.
5 minutes.
No, 2.5 minutes.
Huh?
2.5 minutes. Show cause notice challenge. I will permit you to place this case within 2.5 minutes. Where is the scope at this stage?
I will satisfy your lordship.
Yes.
Let me make my submission. Then your lordship will be satisfied.
Yes.
There is a scope, a wide scope. The complaint was lodged against the private respondent because he used to torture the students. He used to insubordinate to the administrating authority. Now, my lord, FIR was started on the basis of the students' complaint. FIR was started. Now, my lord, the president issued a letter to the director of vocational that this is the situation. What can be done? The director issued a letter.
Why managing committee is before this court?
I'm coming. Why?
Mr. Dotto,
I'm
managing committee is before.
I am
this court?
coming. Kindly.
In aid of a teacher when the board and the DI has taken steps?
No.
I fail to understand.
The specific report I will show to your lordship.
Whatever may be the report. For the first time, I am seeing a writ petition that a show cause notice has been issued upon a teacher in charge and being the assistant teacher of a school, and managing committee is coming in aid of the teacher.
Why he has come? I am satisfied to say kindly.
No, that doesn't.
But we are
This stand of the managing committee does not instill confidence in the mind of the court.
Because
What is this?
Because the entire report. But that's why, my lord,
You are part of the administration.
Yes.
And you are coming with the teacher.
Because
not only this, the managing committee and the teacher in charge.
Because I tell you, lordship, because the entire things have been.
Where is the show cause notice, Ms. Bhattacharya?
Before that, I will show to your lordship.
Please come to the show cause notice straight away.
Before that, entire report kindly see.
Sorry,
Before
please
that-
come to the show cause notice first.
Before the issuing the so-called notice, entire.
Where is the show cause notice, Mr. Dotto? Just a minute. Page 110. Hundred and 20. State abuse in writing. Now, this show cause notice has been issued against Pradeep Kumar Mukhopadhyay.
Yes.
Now, that is a TIC. How the school authority is before this court with the writ petition?
But Manoj, that's why Manoj,
How the writ petition is maintainable?
that's what I mean. But kindly see this letter.
This is
One
not
hundred-
the issue of the school. This is not the common issue of the school. How the school
The
can
issue
come
is
forward?
involved because the director issued a letter to the president. You take steps against the private respondent. Now the director, the president has issued a letter to him that you kindly keep aloof for certain days until the final order is passed from the director. Since that letter has been issued, you immediately he lost this complaint against the teacher in charge, president, and other all teachers. That complaint has not been.
No. Suppose a letter has been, a show cause letter has been issued against X concerning the conduct of Y and Z. Whether Y and Z will come forward or X will come forward.
No, why?
X, because this is a show cause against X. Then X has to satisfy the authority, disciplinary authority. Look here, I am not involved in this matter because it is a feud in between YZ with the authority.
Because these show cause,
That has not been done. This show cause letter has been issued against
The teacher in charge.
against the teacher in charge.
No,
And the managing, not teacher in charge is not a post.
no,
He's
no.
an assistant teacher of the
Yes,
school.
Yes.
Yes. Now the managing committee is coming forward.
But this so-called letter is the centralizing the issue against the private respondent. Because that's why the kind
If a disciplinary proceeding is initiated against a teacher, against an headmaster,
the headmaster
if
will
the
come,
disciplinary
headmaster will
proceeding,
come.
suppose is hypothetically take an issue. If a charge sheet has been issued against the headmaster of the school,
Headmaster will come.
but
Management
the
will
managing
come.
committee will come.
No, management will not come.
That has been
But
that,
yeah,
that is what exactly been done.
and that is why I tell Rossi, why this so-called notice has been is centralizing the issue regarding the private respondents, as the allegation has been raised, and the president has issued this letter.
And why you feel shy in appearing before the authority?
No.
And
No,
responding to this show cause letter.
I have given the reply to so-called. Kindly see. If she,
So he has already given reply.
Yes,
Then
no. This is not my case. But kindly hear me 2 minutes. Page 110, kindly see.
no, at this stage I will not enter into the merit of this case. Sorry, Mr. Dotto.
No, page 100.
No, it is not a luxury petition. I will not permit this, I will not entertain this kind of petition. You have responded to show cause. Let the let your reply to the show cause be
No, I am
considered.
questioning the inquiry report. Kindly.
Sorry, where is the show cause letter?
Because lot of
Where is your reply to the show cause? Unnecessarily dragging the matter
But
before
that
to the
kindly-
court
page
after
110.
responding to the
Kindly
show
see
cause.
page 110. But kindly see, but for my satisfaction, kindly page 110. I have given the reply.
Esho.
No, only one thing. But before that, but kindly see.
Sorry.
Page 110. But if you
Sorry.
but didn't they allow me to?
The writ
But
petition
only one thing.
has been
But kindly.
affidavit service filed on behalf of the petitioner is taken on record. Stop. Writ petition is directed against a show cause letter dated 19 September 2024.
But 110 is the challenge. But
Within
kindly.
bracket,
But if the lawsuit is not being allowed to make my submission, what can be done?
whereby one Pradeep Kumar Mukhopadhyay, being teacher in charge of
But kindly see the 110. I have
Behala High
requested
School.
your lordship. Kindly see 110.
district
Thereafter,
Kolkata-
lordship
Behala
practice
High
for us.
Kolkata was directed to respond within 7 days from the date of receipt of this, from the date of receipt of the said show cause notice. Stop. Mr. Dotto, learned advocate representing the petitioners, submits that Mr. Dotto, learned advocate representing the petitioners, in course of hearing submits that the aforesaid teacher in charge has given reply dated 30th September 2024 to the show cause notice dated 19 September 2024. Stop.
Hello, inquiry report is under challenge. But if you also did not allow me to make my submission.
Next paragraph. Learned advocates representing the board, representing the West Bengal Board of, learned advocate representing the West Bengal Board of Secondary Education has submitted that based on inquiry report dated 29 July 2024, prepared by the concerned District Inspector of Schools, AC Kolkata, show cause letter was issued, show cause notice was issued on 19 September 2024 against the teacher in charge of the aforesaid school. And on receipt of such show cause notice, reply has been submitted by the petitioner on 30th September 2024. Stop. In addition, the to maintainability of the writ petition has been questioned by the respondents. Since the writ petition is not preferred by the teacher in charge, by the said teacher in charge, but by the has been questioned. Writ petition is not only preferred by the teacher in charge, but the managing committee of Behala High School has also been arrayed as writ petitioner number 1 in the cause title. Next paragraph. This court is at a loss as to how the managing committee of the school in question can prefer writ petition questioning the show cause notice issued against the teacher in charge of the said school, who is teacher in charge of the said school. Stop. If right of the petitioner, if right of the said teacher in charge is infringed by issuance of show cause notice, in that event, cause of action warrants filing, cause of action warrants steps, legal steps to be taken by the said teacher in charge himself, not by the managing committee of the said school. Stop. Next paragraph. In addition, next paragraph. In addition thereto, this court finds that on receipt of show cause notice dated 19 September 2024, the teacher in charge has furnished reply with a letter dated 30th September 2024, addressed to the Deputy Secretary within bracket Disciplinary Authority, comma, within bracket Disciplinary Authority, comma, West Bengal Board of Secondary Education. Stop. After furnishing reply to the said show cause notice, now after the kededa, furnishing reply to the said show cause notice by the teacher in charge, takes away the right of the takes away his right to subsequently turn around and challenge the show cause notice.
My inquiry is under challenge. Inquiry report.
Stop. Next paragraph. It needs to be recorded herein that the board has not formally initiated charge sheet against the petitioner in terms of the relevant rules. In terms of the relevant rules, and at that stage, now and at the show cause stage, this court finds that the writ petition is premature. Next paragraph. In view of above discussion, this court is not inclined to interfere with the steps taken by the board as well as other respondent authorities, and accordingly the writ petition stands dismissed. However, there shall be no orders to post urgent Xerox certificate. Opore affidavit service code.
No, you also pass this order. No, you also pass this order. But here, but challenge my inquiry report.
Next matter.
You also did not allow me
Sorry,
to make
Mr.
my
Dotto,
submission.
next matter.
You don't allow me, but I have a case. I have a case.
Yes. Next matter.
Item number 4.
Yes, who is for the petitioner? Nobody.
Presentation form, it is appearing on 8th November, Lordship.
No,
Covering
5th
letter,
November.
Lordship, covering letter 8th November, Lordship.
Maybe. My officer has taken steps in terms of the presentation form, which says it is to be listed on 5th November. At the time of call, no one appears for the petitioners and no accommodation is prayed for. Stop. However, West Bengal Board of Secondary Education is represented by learned advocate. Stop. The writ petitions is dismissed for default. Urgent Xerox certificate copy. Next.
Item number 5.
Grant for the School Service Commission.
Pre-puja special writ petitions.
And this one has been served without any annexures. We don't have any annexures. I double checked with the commission also that whether they have done.
Filing date 7th October 2024. At the time of call, no one appears for the petitioners and no accommodation is prayed for. However, West Bengal Central School Service Commission is represented by learned advocate. Next paragraph, the writ petition stands dismissed for default. Urgent xerox certificate copy. Next. Six.
Ram for the petition.
Come for the commission.
My lord, though there was direction on the last occasion by your lordship.
Yes, yes, no.
No. There was a direction by your lordship on the last occasion, my lord.
These are the expressions the court expressed its view on a case-to-case basis.
Yes, I understand. My lord. That is obvious, man. It happens.
Yes.
It happens. But it also releases the tension inside the courtroom, the heavy tension. It's good.
But Mr. Lahiri, I am watching you.
Yes,
You are
yes.
doing very well.
I'm grateful. to you.
But at the same time, before placing any judgment,
Yes.
please apply your mind whether it is at all necessary or not or relevant or not. You have every right to rely upon
Yes,
judgment.
yes,
Before the
I'll remember, my lord. I'll try to develop myself, my lord. I'll try to develop myself. I'm grateful to your lordship for
Yes.
this guidance, lordship. My lord, though there was a direction upon the state advocate to issue a notice from my side, but I could not trace.
Just a minute, there was a previous order.
Yes, there was a direction. I could not do it, my lord. Lawyer কোথায় গেল? ছয় আপনি লয়ার কোথায়? ছয় আপনি আছেন? মানে পাওয়াই যাচ্ছে না, ওনাকে ট্রেস করতে পারছে না। আজকে ফোন করেছিল, আসার কথা। হ্যাঁ।
Who is appearing for the district inspector school?
My lord, last occasion I served upon the government leader's office, but no one appeared. Your lordship directed me to serve personally. I could not trace the learned advocate. I could not trace.
Previous occasion also nobody appeared.
Nowhere, but my lord, affidavit of service is there. I have served upon the government leader's office. And my
You have served upon government leader's
yes,
office.
yes, affidavit of service possible, my lord, with your lordship's record.
That was prior to the last date of hearing.
Yes. It
You
was
served upon the office of the
office
government.
of the government leader. It is with your lordship's records, but no one appeared. It is on ground of divorce, special ground. But I don't know, my lord, from where the distance came in to become a reason for returning my transfer application. Page 93. My lord, to be candid before your lordship, in terms of your lordship's direction, I could not trace and serve notice. And then the vacation commenced. May I come back on the next week, if your lordship so pleases?
Which district?
District, my lord. Purulia.
Purulia.
So it has been sent to the commission. Actually, DI has already forwarded it to the commission, but with a wrong observation. Page 93.
Mr. Singh, you appeared in this matter. Along with your junior. come forward, obtain instructions. The divorcee has approached this court for her transfer. Now, while considering the transfer application, DI has made an endorsement on the portal. On the
93.
portal, that the distance in between the present school of the petitioner and the place of residence is 24 kilometers. But the line on behalf of the petitioner, it is submitted that it is not, the distance is not 24 kilometers, but it is 96 kilometers.
And it is also
Now,
not a
this since
consideration.
this court directed the DI to obtain the learned advocate represent DI advocate representing the DI to obtain instruction on what basis DI came to the finding that the distance is 24 kilometers. Nobody is happening for the state, so therefore you appear and obtain instruction. Fixing a date within which time you take steps for obtaining instruction.
I'll go to instruction.
And my lord, the distance is also not a consideration when it is special ground of transfer.
Well, let me see.
Yes, it is just written as 24 kilometers. It's not a consideration.
Today
Today matter is taken up for consideration in terms of the order dated 17 September 2024, when no one appears for the state respondents. From the order dated by order dated 17 September 2024, court directed the District Inspector of Schools AC Purulia, being respondent number 4, to inform this court through learned advocate for the state on what basis the respondent number 4 came to a finding that distance in between the present school of the petitioner and her place of residence is 24 kilometers, whereas it was submitted on behalf of the petitioner that the present distance is 96 kilometers. Next paragraph. Since state respondents are not represented today. Now, since state respondents are not represented on previous occasions and also today, Mr. Molloy Singh, learned advocate, who usually represents state respondents, is requested to enter appearance on behalf of the state respondents with a junior of his choice. Stop. Let engagement of Mr. Singh along with his junior be regularized by the office of the learned government. Next paragraph. The learned advocate for the state respondents is directed to obtain instruction learned advocate for the state learned advocate. The District Inspector of Schools AC Purulia, being respondent number 4, is directed to file a report before the next date. File a report on the next date, disclosing on what basis it was found that the distance in between the present school of the petitioner and her place of residence is 24 kilometers. And why petitioner's transfer application was not processed in terms of the relevant rules. Next paragraph. List the matter under the heading motion on 19th November 2024 for further consideration and to enable the respondent number 4 to file report.
Lord, I have handed over one copy. I will give another copy to Mr. Singh. Lord, your lordship stated that not processed. It has been sent to the commission.
Yes.
The lordship has observed that he has not processed it. He has already sent it to the commission. It is pending at the end of the commission.
Then what is the difficulty?
Difficulty, he has given that remark. After that, commission has not done anything.
That distance remark.
Yes.
ও তাহলে
That
ওইখানটা
is the
চেঞ্জ করতে হবে দেখো তো নট প্রসেসটা কেটে দাও বুঝলে since it has been sent to the commission it's not processed because due to this endorsement by the DI on the portal this
Commission
the
has
commission cannot
possibly-
take decision in favor of
But commission ought to have
My lord,
expressed.
we have not taken any decision.
that
Yes, yes.
this court knows.
Yes, yes.
But the apprehension, there is a basis of apprehension that if this distance is indicated, then the commission will definitely consider what is the requirement of transfer.
Yes. But for divorce, there is not such requirement. It's a ground of special transfer.
Then why you are moving this writ petition?
It has not been
That
allowed
is
to
not
me.
required?
It is not,
Only
no,
for
no,
consideration
distance.
order.
You should have waited till the decision to be taken by the commission.
That's why I have come. That's why I have come that let commission take a decision. That's why I
Well,
have
let
come.
me see. Let me see.
That is my prayer. That is my prayer in petition.
Yes, yes, for directing the chairman to take decision.
Yes, they have to apply their
Then
fine.
this court pointed out that if distance is 24 kilometers, then what is the necessity? And what is the basis on which DI has come to a finding that
Two things.
this is the
Yes,
distance?
yes. I submitted.
Really, you have
she's
to
a
have
single
submit
mother.
a report.
I will.
She's a single mother. That's why I have explained in my writ petition. That is a
Report, this report may improve your case. Who knows?
possibly. Possibly. I'm grateful.
চিঠিটা কপি হলো
উনিশ তারিখ।
উনিশ
হ্যাঁ
Call the list.
Item number 7.
But I am for the petitioner in this matter.
In this matter, I am appearing for the state, my lord.
Just a moment.
আমাকে দেয়নি কপি তো। Just now.
Supplementary affidavit, please. Yes.
But I have annexed entire documents, at your up-to-date documents, that your lordship I may find page number 4 of supplementary affidavit, that these are medication I am taking. My lord, just above the medicine, your lordship observed diagnosis, RHD, rheumatoid heart disease, progressive, so and so.
Where from you are reading?
My lord, medicine column, just above medicine column, my lord, page number 4 of supplementary affidavit. But it is on 16 September 2024.
That is the after the order was passed.
My lord, it is going on. This medication is going on.
You have to show the documents before filing the writ petition.
Well, it is going on since there.
I passed order on 11 September 2024.
Yes.
And you are relying upon a document which was issued on 16 September 2024, 4 days after the order passed by this
My
court.
lord, I have talked with my.
No. That will not do.
It is a continuation.
Where is the bona fide in your writ petition in that event?
My lord, 2023 I have annexed.
1 year back, in 2023, no application was made for transfer.
No application made.
Then?
But your lordship asked me whether there is any up-to-date, this petitioner
Yes,
is
what was the order?
under medication or not? Under medication or not?
Page 6, my lord.
Last document annexed is dated 16th May 2023.
20.
Which is more than 1 year before presenting this writ petition on 16th August 2024.
Yes.
Based on medical documents which is position to petitioner. The learned advocate represents the petitioner is prayed for accommodation to file supplementary affidavit including current medical documents. So those documents must be prior to filing of this writ petition. Not in it is not that by filing an supplementary affidavit I have given you opportunity to create documents.
I can understand, my lord.
Even that is normal, my lord.
Page 6,
After
my lord.
medication,
Page 6.
6,
Even
page
after-
6.
after
16th September.
my lord, after
This
medication,
court has not given you opportunity to procure documents afresh.
my lord, procuration is a hard problem.
Yes, where normal?
Everything is normal.
After medication, my lord.
My lord,
After
everything is
medication.
strange.
Diagnosis is, my lord, it has been stated, my lord, after medication, it is
Echocardiography
under
report.
control. So medication is
Normal
required.
range.
Page 6.
Page 6, my lord.
But everything your lordship finds within normal range.
Echocardiography report.
This is my case, my lord. Now, my lord, your lordship have to deny it.
And page 7, your lordship.
Yes, show me that anything alarming in the report
Alarming in the report, my lord, medication.
which requires that your offline application needs to be considered at this stage
My lord,
as a
alarming.
special case.
Yes, my lord. Alarming is, my lord, this medication is continuous, is on continuous process. After medication, it is
Anything serious? Any report?
My lord, medication, this is my medical report, my lord, I am surrendering before your lordship. This is the medical report. Medical report, this is medical, it has been stated several issue is there. Rheumatoid heart disease.
What are the issues?
My lord, diagnosis, my lord, page 4, rheumatoid heart disease.
Issue. by taking advantage of leave granted to file supplementary
I
affidavit.
have talked.
You annex the documents which were issued 4 days after the order passed by this court granting you leave to file supplementary affidavit.
That my lord.
How much cost is to be imposed
My lord, kindly.
for this conduct?
My lord, conduct.
Yes.
These medical
I did
documents
not permitted you to obtain to procure fresh documents. I expected that contemporaneous documents to be annexed to this writ petition,
Right.
considering date of filing of the present writ petition.
My lord, whichever has
That you
supplied-
have failed.
My lord, whichever supplied my client, my lord, I have given. My lord, what can I do, my lord? Kindly consider this aspect too. I have asked to furnish. the
Question needs no question which requires consideration is whether offline transfer application of the petitioner is required to be considered on medical emergency. Stop. It has been recorded and it was recorded in previous order dated 11th September 2024 that though present writ petition was filed on 16th August 2024, but the medical document which was relied upon by the petitioner was dated 16th May 2023, comma 1 year before the date of filing of this writ petition. This court posed query to the learned advocate representing the petitioner whether any contemporaneous medical documents are available which supports the contention of the petitioner that at present petitioner is suffering from serious ailment warranting immediate consideration of offline transfer application of the petitioner. The learned advocate representing the petitioner on 11th September 2024 prayed for leave to file supplementary affidavit disclosing current medical documents. Stop. Next paragraph. Pursuant to the order dated 11th September 2024, now pursuant to the leave granted in terms of the order dated, now pursuant to the leave granted by this court, video order dated 11th September 2024, a supplementary affidavit affirmed on 19th September 2024 is placed before this court, which is taken on record. Next paragraph. On perusal of the supplementary affidavit, it transpires that not a single document has been annexed to the supplementary affidavit.
26 August, my lord, kindly, my lord, there is an bill, my lord, page 20, my lord.
Annexed to the supplementary affidavit.
26th of August.
Medical document code. Medical document annexed to the supplementary document, supplementary affidavit, which were issued just prior to date of filing of this writ petition on 16th August 2024. Stop. Curiously, curiously order was passed by this court. Curiously, last order was passed by this court on 11th September 2024. And to satisfy this court, certain medical documents have been annexed. Copies of certain medical documents have been annexed to the supplementary affidavit, which were issued after the said order was passed on 11th September 2024. Client advocate for the petitioner could not point out any alarming report concerning present health condition of the petitioner, which requires special consideration relating to transfer of the petitioner based on offline application made to the respondent, to the concerned respondent authorities. Next paragraph. In view of aforesaid discussion, this court is not inclined to pass order on this pass order, comma, the writ petition stands dismissed. However, there shall be no orders to cost urgency.
Yeah.
Item number 8.
হ্যাঁ আগের দিন দিয়ে দিছি দিয়ে দিছি জমা
Last order on 23rd August.
রিপোর্ট দেওয়ার ছিল সার্ভিস হয়ে গেছে
লিখে দেবো স্যার।
মান্থলি সেপ্টেম্বর তারপরে এসেছিল তো আমাদের ওর নাম দেবে না হ্যাঁ
Yes, report. Report.
এটা তো আগের অর্ডার
Other order.
রিপোর্ট
The
পাঠাই
report doesn't, I have not received any report.
না না রিপোর্ট
This
পাঠাই
court has directed the
Yes,
district
yes,
inspector of
week
schools,
time
SC
simple.
Dinajpur, to file a report.
As I am told from my learned junior clerk, that only not the request can be made, but of
From
1
one
week time, but next week.
1 week.
One. Next week we'll have some
Next
council.
Very long back order was
My,
13th
I'm not disputing, but
at the time of
I'm
court,
sorry, Milord.
Mr. Banerjee, learned advocate, representing the state respondent, learned additional government pleader, representing the state
Advocate
respondents,
is enough, not.
representing the state respondents, has prayed for extension of time to file report as in terms of the order dated 13th September 2020.
বলে দেবে ভাই।
Next paragraph.
বলে দিয়েছি আমি দিয়ে দেবো।
List the matter under the heading, list the matter under the same heading on 12th November 2024, in order to enable the respondent number 3 to file report.
I'm just.
Respondent number 3 to file report.
I'm deeply obliged to us.
Next,
Just more than zero, no, no.
10.
Item number 9.
I have considered the judgment.
yes,
Well, I have considered the judgment, my lord. That ratio is not applied here. Because of the reason I tell your lordships, I earlier came before this honorable court. I succeeded before this honorable that I'm entitled to. State accepted it, granted the benefit. I enjoyed the benefit even after being headmaster.
what benefit?
Benefit of 2 additional increment for acquiring PhD.
Now I'm going to retire on 31st December this year. Now a dispute has been raised, not regard to my entitlement. Dispute regard raised that whether I am entitled to 3 increment on 1st July of every year. According to him, 3 cannot be entitled at a time, DI. But there is no law that why I'm not entitled to 3.
Whether these
That
3 increments
includes 2
increments.
PhD and 1 yearly.
Yearly increment.
That's the point.
Show me that that the sanctioning of your incremental 2 incremental benefits.
Yes, your losses. That's I tell your losses. Let kindly come to page 40. অর্ডারটা কততে বলো? Your losses straightway come to page 49. The judgment.
Not 40.
Not 40, starting page, my lord. If I'm not wrong, that's starting page.
No, no, this
40
is
your losses can. 40 your
just
losses. 40 kindly can. Now, this was passed during the pendency of my writ petition. Your losses will get it at page 49.
Yes.
Page 49.
Now the order which you are relying upon?
Now, relying upon my lord, questioning impugned order. Impugned order.
Not impugned order, the order based on which you got the, during the pendency, how this writ petition was decided. Previous writ petition.
My lord, the losses page 49. Cool. অর্ডারটা আছে আগের অর্ডারটা এটা 10x করেছে 39 39টা তো দিল
in this order, only direction is payment of arrear benefits.
Which one, my lord?
The order passed by the coordinate bench on 11 December 2015.
Because your loss is page 40, he said I'm entitled to.
Yes, DI said this entitled.
Therefore, consequential will
Now
go arrear.
you have retired it now.
No, I'm going to retire 31st December of this year.
31st December you are going
Yes.
to retire. Now, which order you have challenged?
Now,
Page 77.
77. আমরা ক্ল্যারিফাই যেন কততে করলাম।
But how this benefit was permissible?
Now I tell you, Lord.
Because this benefit was granted with effect from 13th May 2006, when the ROPA 2009 came into existence with effect from 1st January 2006.
First, my lord, I take your losses. Now, this judgment.
Mr. Shannal, let the issue be decided on affidavits. Admissible pensionary benefits can be released.
But
in your
no
favor.
deduction for arrear. Because
Yes.
I've been now they say the overdrawn amount that should not be permitted by any chance.
Overdrawn amount.
They ask for the overdrawn amount refund.
No, but admissible benefits.
No, admissible benefits.
Benefits adjusting the overdrawn from your pensionary benefits.
Overdrawn, how can it be, my lord, at the threshold after judgment of Rafiq Masi, my lord?
No, if admissible benefits are paid, that is pension, gratuity, and the disputed benefit is this incremental benefit, nothing else.
No, no, increment, my lord, I have drawn the increment so far. I'm still drawing.
So you are not required to refund.
That's your
But
lordship.
while releasing your terminal
They cannot
benefit,
adjust the refund also.
yes, otherwise nothing will be, what will be decided in the
So,
final writ petition?
Then
If you get everything, then nothing remains to be decided.
no, no, then your losses, then
That's why court will permit you to accept the admissible benefits. Let the issue be decided on exchange.
well, the admissible benefits cannot be my lord, adjustment of my already amount drawn. Because I tell you, even if I fail, they cannot deduct the overdone amount. Because this is by way of the court's order and the order of the state. And the first thing your losses kindly consider, they have accepted the state. This is a litigation between state and the private citizen. State has not appealed against. And the objection taken, your lordships, if they can show that the 3 increment I am not entitled to, that would have been a different, your lordships. Yearly increment.
When the first request was made by the DI, because come to page 77.
77?
7.
Yes, your lordships.
It is stated. It is stated that he was requested for compliance of the objection raised for disposal of the pension file of so and so of the school who will retire on 31st December.
Exactly. Page 70. 70. Kindly first objection 70.
What is the date of this objection?
6 July 2020.
Where from you are getting this?
No, that's your losses. I'm giving your losses. Just a minute. I will take your losses. 6th or 5th July. Your losses will get it at the bottom. 6 July 2024. And log in your losses will find it's not totally printed. Last successfully log in 5th July. Your losses will not get the.
Yes, 5th July.
5th July.
At the top right hand side.
Exactly. Your losses will not get the year only. So even if I lose before your losses, because of the division bench judgment, even they can't get the refund. So how can they adjust it? This is one thing.
The principle of
exactly. The second thing, your losses. This is a litigation between the state and the private citizen. I have succeeded, good, bad, indifferent. The law which the division bench comes in 2019, that cannot upset the earlier judgment.
What was the order passed in 21586 W of 2007?
Oh, that's your losses. I take your loss. Page 37. Page 39, I'm sorry. 37? Just. 37 was also the consideration order.
Page 37.
Is a consideration order.
Since you have availed of the benefits under ROPA 2009.
I tell you, your losses probably bothered by the subsequent judgment. Now your losses kindly come to page 39. The order passed after the first.
If it is wrongly fixed benefit.
First, refund cannot be taken.
Master of the school.
Refund cannot be taken. They cannot overdone amount. Second, your losses, I take your losses to this.
Very well, I will protect you to the extent of refund, but so far fixation of your pay from this date, that will be in terms of the ROPA 2009 rules. Taking note of the observations made by the...
No, your losses will not call for affidavit.
Yes.
You will not call for affidavit for 77 because I'm questioning.
Because these issues are issues have already been decided.
I tell you, now kindly keep your...
The issue which is in your favor, that has been decided by the Honorable Supreme Court.
I'm coming to
the issue which is against you, that is decided by the Honorable Division Bench.
I tell you. Now, kindly, your losses, allow me to make deliver my submissions. Your losses, the judgment of 2019 should not be applied here because the right has been crystallized by the order of the DI and the order of the court. prior to the judgment of the division bench.
It is a wrong order.
No, my lord, I tell your lordships, even in wrong order, your lordships, if your lordship give me a day's time, because I have just come down today and straightway come, because at my instance this was kept by your lordships. Kindly, for my lord, in all probability your lordship has come across this judgment. A law decided by the High Court in a particular point. Now, parties enjoyed the benefit. Same point in another matter going before the Supreme Court. Supreme Court says, no, that judgment is not right. So this is not right thing. In another matter.
Mr. Sannal, the situation is different here.
No, my lord, I tell you.
Situation is why different? Because it is a matter relating to granting of incremental benefits. The court directed the authority to decide in accordance with law. The authority wrongly granted.
No.
Yes. Nothing has been decided by the district inspector.
Yes, page 39, page 39.
Page 40.
Page, I come to your lordship, page 39.
In the memo dated page 40, nothing has been decided.
No.
Straightway, there with effect from 13th May 2006.
No, this is not the decision.
It has been granted.
No, the decision
Now,
is
that if it is a decision, that decision is in the teeth of the decision of the Honorable Division
No,
Bench.
your lordship.
That is not permissible.
No.
Question is, Mr. Sannal, have you accepted the benefits under ROPA 2009?
But I am coming to kindly consider page 39. This is the decision. Factually, we should not be wrong, my lord. I cannot, my lord. Page 39 is the decision pursuant to 2007 writ petition. Page not the page 40. Page 40 is another. I am telling. I should tell your lordship the factual aspect.
This is also a wrong decision.
Exactly. I questioned this in 2011 writ
This
petition.
page 39 decision is also wrong.
I questioned this. I tell you, factually should not be wrong.
Very well. In that event, if you want to develop your points, then let the issue be decided on exchange of affidavits. In the meantime, on completion of the tenure of the petitioner is entitled to get the admissible benefits.
But your lordship, refund stay their hands at any event, my lord. They cannot take the overdrawal amount.
But the amount is to be adjusted from your pensionary benefits. That is the purport of admissible benefits. If you get everything, what is to be decided?
No, everything. Sure. This is not everything, your lordship. But kindly, this is not everything. Overdrawn cannot be.
No, overdrawn. I will not permit them to take the amount.
Clarify that.
But while paying the benefits, releasing the retirement benefits, they will pay the admissible benefits as per their calculation.
Well, that's your lordship. Subject
as per their calculation.
Subject to disposal of
yes, definitely. As per their calculation. I will not permit them to take the refund from you, which you are apprehending.
They have said it.
Yes, that I will restrain them.
Do that.
But they will pay the admissible benefits.
Do that. But subject to the result of the writ petition.
Yes. By presenting this writ petition, challenge has been thrown to the decision of the District Inspector of Schools, within bracket AC, close bracket, Birabhum, dated 23rd July 2024, whereby whereby the concerned District Inspector of Schools has insisted the petitioner, being the headmaster of a government-aided high school, to resubmit his pension papers since, according to the District Inspector of Schools, sanction of incremental benefits with effect from 7th July 2006, with effect from 1st July 2006, was impermissible. Stop. Mr. Sharnal, learned counsel representing the petitioner, submits that it is true that on 1st July 2006, petitioner was sanctioned 3 incremental benefits, out of which 1st of July 2006.
No, that's wrong on his part.
But the incremental benefits were sanctioned in your favor on and from.
Allowed only yearly incremental benefits 1st July. But the rest 30th March, that's he is trying to committing mistake. Malad, in that this part I must succeed. He can't. He has jumbled up the situation.
From rest 2 benefits you received from 13th May 2000.
Exactly.
তার আগে সেন্টেন্সটা একটু শুনি। হ্যাঁ, বল। না না, ওটা ঠিক আছে।
Since according to the district school by sanctioning of incremental benefits with the July 2006, not in
Yes. And learned counsel representing the petitioner submits submits that from 1st July 2006, one yearly incremental benefit was sanctioned in favor of the petitioner, but other 2 additional incremental benefits were allowed with effect from 13th May 2006 in recognition of PhD degree obtained by the petitioner, and 13th May 2006 was the date of convocation for conferring such degree. Stop. It is also contended that at the time of settling the pensionary benefits in favor of the petitioners, in favor of the petitioner, his entitlement to draw 2 additional incremental benefits with effect from 13th May 2006 cannot be questioned.
In fact, he has not questioned also. What he says, I cannot get 3 incremental in a particular year.
Next paragraph.
Anyhow, you're saying.
On the contrary, Mr. Dotto, learned advocate representing the state respondent, submits that the petitioner has availed of the benefits under RUPA 2009 with effect from 1st January 2006, and in terms of the RUPA rules of 2009, there is no provision to grant there is no provision, or there was no provision to allow 2 additional incremental benefits for acquiring PhD degree, which prompted the present district inspector of schools within bracket AC close bracket Birbhum to issue memo dated 23rd July 2004. 23rd July 2024. 2024, not 2024. Stop. In support of such contention, reliance has been placed on behalf of the state respondents on the decision of the Honorable Division Bench reported in 2009, Volume 2, CHN Cal 221, within bracket State of West Bengal versus Chandrabhushan Dwivedi, close bracket. Next paragraph. Having considered the respective submissions made on behalf of the parties, this court finds that the issue needs to be decided on exchange of affidavits. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 1 week thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for expeditious hearing after the time fixed herein above for exchanging affidavits. Stop. Whether the school is represented today. Next paragraph. The learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file affidavit of service on the next date. Next paragraph. This court also, this court is also this court is required to take into consideration the date of superannuation of the petitioner on 31st December 2024. And if 31st December 2024, stop. It is, no, stop. Taking note of the contents of the memo dated 23rd July 2024, it appears till date, claim of pensionary benefits of the petitioner have not been settled in view of the stand taken by the concerned district inspector of schools within bracket AC close bracket Birbhum, as it emanates from the said memo dated 23rd July 2024. Stop. If next stop. If the writ petition is not decided before 23rd decided before the superannuation of the petitioner, in that event, state respondents are directed to release admissible retirement benefits to the petitioner by 4 weeks from the date of superannuation of the petitioner. Stop. However, it is made clear that petitioner shall not be insisted upon to make refund of alleged excess drawn amount.
Overdrawn amount.
Alleged excess drawn amount. Stop.
Overdrawn, they have used language overdrawn.
Alleged overdrawn amount. Stop. Stop. Such steps shall be taken by the state authorities without prejudice to the rights and contentions in the present writ petition.
Lordship, fixation from date as per ROPA. Or
Fixation to temporary fixation.
It is already
whatever
there.
you like.
What is necessary that the DI will not insist upon the petitioner to refund.
or refund.
But the admissible benefits I have stated that the admissible benefits are to be released in favor of the petitioner. So you can adjust it from the from gratuity.
Item number 10.
Yes.
Palatability service.
Yeah. Yeah. Yes, whether the school is represented today, whether the issue has been resolved.
Lot of things came up at the time of hearing. The school have submitted the attendance register. Your lordship knows that at least 70% attendance is required, both including class 9 and 10, to be eligible for April month. So, my lord, in class 9, he attended only 29 days, and in class 10, he attended till up to June. He attended only 24 days.
So the 75% attendance is
Only 3 days. 3 days.
so 70% attendance is not there.
Number
But there is a reason. It is recorded in the audit, has been submitted at a learned advocate petition. The petitioner's son is at present not permitted to attend classes.
No. My lord,
Because there was no registration in class 9.
class 9. Because my lord, the last date of registration was in the month of December 2023. When he was in class 9, for appearing in 2025 Madhyamik, 2023 registration in class 9 is to be done. So that he has not done within time. He has not submitted his birth certificate because he had never had any birth certificate, or what we don't know, because he has obtained the birth certificate in the month of May 2024. Very recently. So, my lord, first thing is not registered. 1 point. Second, even if registered, this attendance is not there. So, not qualified. Thereafter, your lordship, then also, lordship, at the time of hearing, my lord, even considering that a career of a student, my lord, it was in the hearing, it was proposed from the part of the president that we may allow you, only one thing is to be done, you make a declaration regarding what latches is on your part, and deposit a process fee, late process fee of 5,000 rupees for late process fee, and fill up the registration form, because it is to be filled up, and the registration form, fill up the standard fee is 155 rupees. You do all these things, and we will, on compassionate ground, we will allow you, that we don't want 1 year of a student. They have declined. They said we will not do, and they walked out from the hearing.
Why?
Well, that instruction, my lord, I have to take. My lord, as per
I will
instruction.
fix a date,
Yes.
appear before the concerned authority of the board, deposit the requisite fees,
Yes.
and complete the formalities so that the registration of the petitioner is complete.
My lord, that as per instruction.
Why you have your
My lord, as
petitioner
per
has
instruction
declined?
of my client, my lord, that was not so, my lord. For that reason, my lord, date may be fixed, my lord. My client.
Unnecessarily. Today this matter could have been disposed of.
As per instruction of my client, that was not.
That is
so,
not
my lord.
fair so far the guardian of the petitioner is concerned.
My lord, that was not approached. My client is also present before your lordship, my lord. That was not approached to my client.
So let me fix up a date, do the
Yes.
needful.
First of all, lordship, the registration form is to be filled up through the school. So, my lord, school part is very important.
So I'll direct the school authority, headmaster of the school, and the petitioner to appear before the concerned authority of the board, and they will complete the formalities, and the registration number will be allotted in favor of the petitioner. And
All this
requisite fees.
late process.
Requisite fees includes everything.
Whatever they are. Whatever amount the board has asked.
In terms of the previous order dated 13 September 2024, matter is taken up for consideration in presence of the learned advocates representing the petitioner, school authority of.
This is Bagnan High School. Bagnan High School.
Bagnan High School, District Howrah, and the West Bengal Board of Secondary Education. Stop. Next paragraph, Miss Koeli Bhattacharjee, learned advocate representing the board, has submitted that submitted that decision has been taken by the concerned authority of the board to relax the conditions for registration of the petitioner, for son of the petitioner, for registration of son of the petitioner, in order to permit the student to participate in Madhyamik examination 2025. Stop. It is further submitted that the student did not have requisite percentage of attendance in the school during his studies in class 9 and 10, and same can only be relaxed upon payment of requisite fees. Stop. It is also submitted that the headmaster of the school. Now, it is also submitted that the student is required to submit filled in form submit filled in form through the headmaster, through the school authority, through the authority of Bagnan High School immediately for allotting registration number. Stop. It is further submitted that though opportunity was granted to the student and his guardian to take steps, but no necessary steps were taken in the meantime. No necessary steps have been taken in the meantime. Stop. However, it is submitted on behalf of the board that if direction is given by this court on completion of formalities and depositing requisite fees, registration process shall be completed at the earliest. Next paragraph. Having considered the submissions made on behalf of the board, this court directs the petitioner and his son. Directs the petitioner and his son and the headmaster of Bagnan High School to appear before which authority?
Before the board, before the secretary of the.
To appear before the secretary of the board on, tell me a date according to your convenience, so far the board is concerned. On 12th November.
সরকারি ছুটি নেই তো 12 নভেম্বর?
On 12th November 2024 at 12 noon. When the guardian shall deposit, when the petitioner shall deposit requisite fees and filled in form with the assistance of the headmaster of the school, and on receipt of forms and fees, board shall take necessary steps.
This late fee of process fee of 5,000 maybe.
Board shall take necessary steps for allotting registration number within 48 hours thereafter.
Yes, well, from 20th, the test examination will be held.
Stop. Stop. It is made clear that for completing the process of completing the registration, petitioner is required to put in requisite fees, including late fine.
It means late process fee of rupees 5,000.
Including late process fee of rupees 5,000. Next paragraph. It is further submitted on behalf of the school authority that test examination is going to commence on 20th, on and from 20th November 2024. Stop. If registration process is completed in terms of this order by the board, petition the son of the petitioner shall be permitted to participate in test examination. Stop. Next paragraph. With the aforesaid direction, the writ petition stands disposed of. There shall be no need to post further.
Mala, I am representing for the state, my lord. You also record that.
Yes, enter your appearance.
Item number 11.
Miss Dedhabol, you had the occasion to appear on behalf of the petitioner in one matter with regard to deputing a teacher in another school since the original school, the first school where the petitioner was working, did not have the roll strength. I passed an order. Similar matter has come up before me.
Mr. Lahiri.
Yes. Please supply the copy of this order to my officer.
Yes. Great.
I am for the petitioner. Immediate service and
Item number 11.
and reply.
In terms of the last order, my lord, the DI
প্রতিদিন order আচ্ছা আচ্ছা ওদের কাছে আছে। হ্যাঁ, ঠিক আছে স্কুল আচ্ছা Yes, proceed.
Go outside, please go outside. Just don't make any noise. Your report.
There are submitted ballot. A meeting has been held by the DI Township Lordship's order, madam. Some papers have been not been supplied by the school authority. Along with the legal health certificate, paragraph ballot 3 and 4.
But for for releasing the family pension, legal heir certificate is not required. He is the wife of the deceased teacher. No legal heir certificate is required.
Certificate issued by the Pradhan, my lord.
He have already applied to the DM. My lord. DM
Maybe, but that is not required. When the wife is alive and she has been nominated by the teacher concerned, no legal heir certificate is required.
Page 29, my lord. Panchayat authority already issued.
Well, she has in the petition, she has all, I mean, nothing, she has not said anything. But the
Well, come back tomorrow.
Tomorrow.
details,
Take it back. Yes.
But I have something to say in this matter for this school.
Item number 4, I have missed the list.
Yes.
Item number 4. Has been
Prior rising, may I pay for leave to file this writ application? It is regarding to the recruitment of SSC GD constable.
No, I have refused your prayer in the morning.
Yes, your lordship given.
I have refused your prayer. Sorry.
No, no, no.
This is the leave to move, my lord.
কখন থেকে শুধু এই কোর্টে ঠিক আছে দেখি বোধ না থাকলে হবে না করলাম
My lord, may I be permitted to seek leave to file these 8 writ petitions, my lord, regarding the recruitment of SSC GD, my lord. My lord, all the petitioners, my lord, they have been rejected due to the height, my lord. But the deficiency of height is only 5 millimeters, my lord. And as per their guidelines, my lord, if it is at less than 5, my lord, then it will hold as the next highest level, that is the requirement height, that is 170. And they are 169.56 like this. All these 8 petitioners, my lord, I'm seeking leave.
what is the urgency
My lord, up to 8, this medical will go on. Thereafter, within 20.
medical
This medical proceeding will go on, my lord. Thereafter, my lord, from 20 by 21st of this month, my lord, the merit list will be published.
when this the physical verification was started and when the petitioners participated for physical verification.
Let me check. This October.
When the petitioners participated for in the physical verification.
It is a process. It started.
How many
long
petitioners
ago,
are there?
it's a department.
How many petitioners are there?
Only 8.
How they can join together?
My lord.
How they can join together?
No, the different 8 different petitions, separated petition.
Yes, when they have participated in physical verification process.
My lord, on different dates, my lord.
When this
In
what is
October 8, October 10.
So why you are coming today?
No, my lord, the DME, RME, all were conducted, my lord. Thereafter, it's a procedure, my lord.
For which post?
It's a constable GD. It's conducted by the Staff Selection Commission.
Constable GD under which department?
The various department, my lord. It is conducted by the Staff Selection Commission, and at present the nodal conducting officer, my lord, the authority is the CRPF. But they will join in CRPF, SSB, Assam Rifles, BSF.
So up to 8th of November, this physical verification will continue.
Right.
And thereafter, the final panel will be prepared. Whether the petitioners have been adjudged as disqualified.
Yes, my lord. In medical, they were declared as disqualified for the reason of height. The cutoff height is 170, and all of these 8 petitioners, my lord, up to 169.56 or 66 like this.
But a matter কবে fix করলাম সকাল আমরা file it on 7th.
I'm deeply obliged to your lordship. Please. I'm glad to
আধা ঘন্টা পর পাঠা
I'm grateful to your lordship.
Yes.
Item number 29 from monthly list of appellate side.
Acquisition. Right. This is my application, my lord. This writ petition is for praying for transfer. But all the respondents are served, my lord, back in October 3.
Yes.
This year. They have been served on 3rd of October 2024. My lord, here, my lord, initially the writ petitioner preferred a writ petition.
You are appealing for?
Yes, my lord.
State. What about the School Service Commission and
all of them are served. My lord, previously when I filed this writ petition, my lord, I did not annex my lord, the relevant document of my lord this extract of the court order. So this is why I, my lord, prayed for a liberty to withdraw and thereafter, my lord, to file afresh. My lord, this has been, my lord, graciously granted by this honorable court, and after that, my lord, I filed this statement. My lord, if I just directly take your, my lord, this is an application for transfer on the ground of divorce. So, my lord, if I
Court
take,
C.
yes, my lord, page number 20 of my writ petition once.
Now, have you made an application online? Online?
This has been rejected by the school online itself. My lord, page number 20, you will see that. The serial number. But this has been kept pending at the end of the school. I stand corrected.
But it has been sent back from School Service Commission.
Prior application, the previous application, which was made on the ground of my asthma, bronchial disease. So, my lord, the School Service Commission said.
Then why you did not take the, why you did not apply for
I-
transfer on divorce?
Subject to correction. At that time, I was also already divorced. That is true. In 2018, my lord, I was divorced. So, my lord, I chose, my lord, to make the application on medical ground on my bronchial disease. Now, my lord, what happens here? The bronchial.
Then the present application was filed on 28th November.
Yes. And my lord, the school
Now,
service.
school is not taking any steps.
Not taking any steps.
So, who is appearing for the school authority?
No one appearing, my lord. I have served, they have received, my lord, on 3rd of October. And I just beseech your lordship, my lord.
How the issue can be decided in absence of the school?
My lord, right, my lord. If I just want, may I just submit one thing? Because this is an application on the ground of divorce. This can be, my lord, verified by the TI only. And if the DI sees that my application is in line.
Filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner has grievance against the school authority of Helen Sharodamoni Balika Vidyalaya within bracket ages, district Hooghly, being respondent number 6 to 8. Respondent number 6 to 8. Since the said school authority did not forward the transfer application of the petitioner, which was made on Utsotsi portal on 28 November 2022, comma, to the District Inspector of Schools, to the concerned District Inspector of Schools. Stop. Next paragraph, having considered the grievance of the petitioner, this court finds this court finds this court desires to hear the school authority of Helen Sharodamoni Balika Vidyalaya within bracket ages.
Right.
Next paragraph. The learned advocate for the petitioner is directed to serve further notice upon the respondent upon the respondent number 6 to 7, respondent number 6 to 8, enclosing copy of this enclosing copy of the order by 7 days from date, and file affidavit of service on the adjourned date.
Right.
Next paragraph. However, it is made clear if on the adjourned date the school authority of Helen Sharodamoni Balika Vidyalaya within bracket HS is not represented in spite of service of notice, appropriate order shall be passed against the said school authority for ensuring representation on behalf of the said authority, on behalf of the said school authority.
Right.
Next. Stop. Next matter.
But the matter is posted.
Yes, list the matter under the heading motion on 20th November 2024.
Great. The affidavit of service will not be taken.
উপরে দিয়ে দাও affidavit of service file on police.
Great.
Item number 64.
Add another line. Since the West Bengal Central School Service Commission is not represented today, the learned advocate for the petitioner is directed to serve another notice upon the commission. Another notice upon the commission before the next date.
Great.
Next.
Item number 64.
Not I beg to appear for the petition.
But on the last occasion, your lordship had raised two queries, my lord. With regard to the first query, that when the exact date, my lord, I had a detailed discussion, my lord, the client is unable to.
The upper primary.
Yes, my lord, upper primary.
Yes.
My lord, he's unable to ascertain, my lord, the exact date. It must be with, between 4th of January to 20th of January.
You have
Pursuant to the.
uploaded.
Yes, my lord.
Where
Pursuant-
you have stated.
My lord, para 16, my lord. The exact date is not mentioned.
An omnibus statement. Where is the specification particulars?
Or the exact date, the client also cannot ascertain, my lord.
Then
My
if,
lord,
if you have uploaded and you are not called for verification, you are not called for verification, or your name was not after verification, after uploading, verification was done. After uploading, verification was done, where presence of the candidates were not necessary.
No, not it.
Thereafter, a list was prepared.
So after that, then certain cases were being filed and then the grievance hearing.
True, that I know,
So
but apart from grievance hearing, those who uploaded the documents and those who were found eligible, their names were included in the panel.
yes, but that panel was challenged because it did not show the breakup of marks. Then the court directed that you publish with the breakup of marks. We published with the breakup of marks. The court was satisfied and said proceed. Then at the same time, the court also directed those who are not in the panel or waiting list, if they are agreed, then they are to be given personal hearings. And then the grievance hearing mechanism was set up pursuant to the direction.
So then, if you have uploaded the uploaded your testimonials, and in spite of that, your name did not feature in the merit list, it is a merit list. Then why you did not raise grievance before the grievance redressal committee?
No, it's a specific awardment made by the petitioner that she had no knowledge, my lord, of the grievance hearing. I have nothing else to submit, my lord.
Petitioners
Petitioner was otherwise ineligible due to want of merit. Both the petitions
are not trained candidates.
Yes, both of them. There are two petitioners in this application. But they did not come for grievance. Had they come for grievance, then
That could have been addressed.
Plain.
Petitioners applied for being considered in connection with first state level selection test 2016 within bracket upper primary. By presenting this writ petition, petitioners have prayed for verification of their testimonials for being considered in the said selection process. And if petitioners are found eligible, their names are to be included in the merit list for appointment in the post of assistant teacher within bracket upper primary. Stop. Next paragraph. In connection with first SLST 2016 upper primary within bracket, second phase of selection process started from rule 12 within bracket 2 stage on uploading of testimonials by the candidates for verification. Stop. In the present case, apart from a general statement made in paragraph 16 that petitioners uploaded their documents, nothing has been disclosed on which date petitioner uploaded their documents for verification. Stop. On query being posed to the learned advocate representing the petitioners as to why petitioners, when found that in spite of uploading their documents, verification was not made and their names did not feature in the merit list, comma. Grievance was not raised before the grievance redressal committee. Stop. Court does not get any satisfactory reply. Court does not get satisfactory reply. From the side of the petitioners. Next paragraph. If court proceeds on the premise that petitioners uploaded their documents in the second phase of selection process on the website of the School Service Commission. In spite of that, upon verification, their names did not feature in the merit list. They should have raised grievance before the grievance redressal committee. So, such steps have not been taken. It transpires that such steps have not been taken by the petitioners. Next paragraph. It is submitted on behalf of the West Bengal Central School Service Commission that the merit list has been finalized and counseling is going on. Therefore, at this belated stage, no relief can be granted to the petitioners, thereby directing the concerned authority of the commission to verify their testimonials. Step. Next paragraph. Writ petitions, hence writ petition stands dismissed. There shall be no orders to post arguments. Next.
Item number 65. 65, I am for the petition.
State কি করে হবে এটা তো ডিআই রিফিউজাল হবে না আমাদের বিষয়ের কাছে কত চলছে কত চলছে 201 200 ছিল কত থেকে বেড়েছে 197 মতো ছিল কি রে ভাই হয়নি কিছু ভুল করে বেরিয়ে গেছে এত করে উঠে গেছে ঠিক মতো করে উঠবে আর একটু ব্রিফ নিয়ে আমার কি ব্রিফটা চাইতে হবে এটা করে সেখানে অ্যাপ্লিকেশন 201 চলছে এগুলো কি কল করলো
Yes, where is the affidavit on behalf of the school authority?
School authority, my lord, they have filed and I have given a
Who
copy.
is appearing for the school authority?
Mr. Badi.
They have filed affidavit. You have filed your exception. File your exception. What they have stated in their
They have stated that only I am the only English teacher in HS section, but it is the case of the petitioner. I have annexed the staff pattern. Apart from the petitioner, there are 3 English teachers. One of them has MA degree who can teach the HS section English. I have annexed the staff pattern, and my application is pending before the DI. Only once I have applied, it was twice I applied. First application rejected by the school authority. Subsequent application forwarded to the DI. It is pending before the DI. Now, HY took a stand that the distance from my present address to school below 25 kilometers. But earlier occasion, I have stated the rule stated distance from one school to another school required more than 25 kilometers. The rule it has stated. And I have annexed my distance is 27 kilometers. I have annexed the
one school to another school means?
In which school I have transfer must be beyond 25 kilometers as per rule. That is
why, but when the second application is pending before the DI, why the present application has been filed?
No, my lord. First application was rejected by the school authority due to some issue.
Yes, but you filed a second application which was forwarded to the DI.
DI. With note that below 25 kilometer, kindly see the status page 19 below once. Well, at page 20, first application, well, at 18th of February 2022, it was serial number 5. It was rejected by the school authority as per the decision of SMC. The application of General Parijat Pal was not con due to the fact that distance 25 kilometer. Next, my lord, on 6th of September 2022, I have applied. My lord, HY took a note that single teacher PG 2021, no vacancy has been filled up. Parijat Pal is the only English teacher with PG to teach HS level officially. Moreover, the distance 24 kilometer. Now, my lord.
Now, in the previous school, in the first occasion when you have applied for transfer, you applied to the same school as it has been same school as indicated in your third application.
No, different
transfer.
Who I have selected different separate school, but they have stated the distance from my residence to present school. They have took the point that distance from my present residence to school is below 24 kilometers. That I have disputed. I have annexed 27 kilometers.
Where is the rule 2015?
I have
rule 3.
Yes. I have missed that. 2015 rule
বলা যাচ্ছে তুই appropriate কাজে চলে যাবে সামনে
my lord, kindly see rule 3 sub rule 2. So my application is pending before the DI. Only I want to, since I am not a single teacher, but I have annexed the.
But what is the distance in between your school and the residence?
Yes, 27 kilometer.
School and residence.
My lord. Yes, 27 kilometer.
School and residence. Your residence.
Yes, page 16. 27 kilometers.
That is the distance in between your present school and the school where you are seeking transfer.
Yes.
But what is the distance in between your school and residence?
My school and present residence, 27 kilometers.
27 kilometers. And the distance in between the present school and the transferred school?
Transfer 3 I have selected.
That is also 27 kilometers.
That is far beyond. This above 20, definitely above 20.
On what basis you are submitting this?
My lord, 27, my lord,
because there is not much difference in between 25 kilometers and 27 kilometers. How you get this information? The distance is 27, not 25.
Between two schools, present school, then my lord, I have to furnish that.
Mere statement will not do.
My lord, that information I require to Since my application, my lord, observed it or disposed it of to the considering their application DI, since it is an administrative work, my lord, since they have take this point that I am single teacher, that I am disputing as per Sabina.
Yes, that you have said that there are other teachers. But with regard to distance?
Distance, my lord, they are taking this point, but DI is the ultimate authority to decide it. I have my.
Have you obtained the printout of Google Map?
Between two
Yes,
schools?
yes.
No.
Then why not?
My lord, that.
Why not?
Then, my lord, I take.
In other matters you do. In this matter, why you have not annexed that document? That as per Google Map, what is the distance between the two schools?
Present address to to my present school. My present residence to school is 27 that I have annexed. But to school, my lord,
because you are submitting that in terms of Rule 3, Sub Rule 2, it is not the distance in between the residence and the school, but it is in between the two schools.
Yes.
From the present school to the school where petitioner is seeking transfer. If that is the position, then the school is saying it is less than 25 kilometers. You are saying it is 27 kilometers. So it is the difference is very narrow. So that's why on what basis you are submitting that it is 27 kilometers.
my lord, subject to correction.
Better you exchange your affidavit.
My lord, subject to correction. They are taking this point, my residence to present school. They are not taking this point that do two schools between present school to transfer school. They are taking this point that is illegal. Finally,
so in their affidavit, they have stated that distance in between your residence and the present
yes,
school.
yes, my lord. Kindly see their affidavit also. In their affidavit, they have also stated. They have annexed the Google Map.
You will inform the school authority. Mr. Badi is appearing. Inform the school authority and come back. Issue.
State's presence will also be necessary.
Yes.
State's presence will also be necessary because
Last occasion, state was also
distance verification also they will do.
State was there last
Yes.
occasion. In terms of the order dated 14th August 2024, matter is taken up for consideration when no one is representing the school authority of Kopileshwarpur High School within bracket HS close bracket district North 24 Parganas and the state respondents. So, however, it has been submitted by the learned advocate representing the petitioner that in terms of the directions, in terms of the previous direction, affidavit has been filed on behalf of the aforesaid school authority and the petitioner has used an exception to this affidavit. Stop. The exception to the affidavit has been filed today and the same. Have you filed that exception?
Yes, my lord.
Is filed today and the same is taken on record. Yes. Stop. The next paragraph. The learned advocate for the petitioner is directed to serve notice upon the learned advocates representing the school representing the school authority as well as the state respondents enclosing copy of this order by November 2024. Stop. List the matter under the same heading on 13th November 2024.
I am extremely extremely.
Rule says, Dr. Patro, that in between two schools, not the residence and the school.
Item number 66.
66 milligram for the petition. In terms of the previous rejection, my lord, copy was served upon the state respondent, my lord. This is the affidavit of service.
Have you served upon the learned advocate?
Advocate, my lord. Mr. Bidhan Biswas, my lord. Inquired of
He is still in the panel.
he inquired of from the office, my lord. Found that he was engaged in this.
He was engaged. But it is his 2023 petition. Now
Then, my
panel has
lord,
been reshuffled. Whether still he is in the panel?
May I serve the client government pleader again?
That will not do. First get the information that whether still he is in the panel or not.
Let me take information.
What is the matter about?
The matter regarding the child care leave, my lord. 15
Again,
days.
child care leave.
15 days, my lord. On account of, my lord, the examination
The
of the
school
son.
has not sanctioned it.
No.
Who
he
is
denied.
hearing for the school authority? Then the school has to be heard.
The school authority, my lord, was served earlier, my lord. Earlier affidavit of service.
But no one appeared for the school authority previously.
No, no one. No one.
Then why you have not served upon the school authority? It's a case of sanctioning child care leave.
Served
So
by
your
the
grievance
earlier
is against, maybe, but it's 2023 petition. This court directed you to serve
last
notice upon the
occasion,
state, but you should have also served upon the school because the grievance is primarily against the school.
But last occasion, the headmaster had called my client and said that kindly withdraw, I will regularize all this.
That is
so
different
that is
thing.
why we took
Issue has
adjournment.
not been settled.
Not settled. Today the school is open. So my lord, I asked my client to take instruction whether that is settled or not. So my lord, he said that we need 7 days time, my lord, whether this it will be regularized.
Why you are not submitting this?
But the last occasion I submitted, that is why adjournment was granted.
So now it has not been, it has been set. Has it been settled?
Today it has. I have not taken instruction, but today is open, my lord. Today the school is open, first day after the puja vacation. So when I need 7 days time, my lord, let me ask my client and my lord, I'll serve the copy upon the state.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. No, on behalf of the affidavit of service filed on behalf of the petitioner is taken on record, showing service upon the learned advocate representing, showing service of notice upon the learned advocate representing the state respondents. Stop. However, on here, next paragraph. However, on hearing the learned advocate representing the petitioner, it appears that the grievance is primarily against the school authority of Talit Gureshwar
High School.
Gaureshwar High School, District Bardwan, which District Purva Bardhaman. Since the said school authority has not sanctioned childcare leave as applied for by the petitioner. Stop. Next paragraph. It is also submitted on behalf of the petitioner that there is chance of settlement of the issue involved in this writ petition. Stop. Prayer is made for adjourning the writ petition for adjourning the writ petition for some time. Next paragraph. Let the matter appear under the heading motion in the monthly combined list of December 2024. Stop. If the issue is not settled before the next date, the learned advocate for the if the issue is not settled before the next date, if the issue is not settled, if the issue is not settled, the learned advocate for the petitioner is directed to serve notice and upon the learned advocates representing the state respondents as well as upon the school authority before the next date of hearing of this writ petition. Stop. Hearing of the writ petition and to file affidavit of service. Next.
Item number 67,
Lord, I am appealing for the petitioner, my lord. On last occasion, my lord's order was to serve notice upon the learned state advocate. I have already served, my lord. I find that the affidavit of service has not yet been made, but I beg for not today only, so that lordship kindly takes up the matter tomorrow.
Yes, have you served?
I have served, my lord. Mr. Prantik Gorai, he is appearing in the matter, my lord. Just a short while ago, I talked to him, and he was supposed to come. My lord.
When you have served?
My lord, I served on 3rd of October, my lord. And after that, I have reminded him.
Where is the affidavit of service?
My lord, that is why I am praying for not today only.
What is the matter about?
This is about, my lord, the interest on gratuity.
Interest on gratuity?
He is supposed to come, and I talked to him.
Show me that you have served upon the state.
My lord.
Yes, tell me the facts.
My lord, this is interest on gratuity matter, my lord. Similar order was passed by my lord.
Yes, give me the order.
Assistant teacher.
Retired on 30th June 2016.
My lord, 30th June 2016. And
First PPO
first
17
PPO
January
was
2019.
17th of January 2019. And thereafter, the revised PPO was issued on 16th September 2020.
Under ROPA 19.
My lord.
Issue. In spite of service of notice upon the learned advocate representing the state respondents, comma, state respondents are not represented today. Notice dated 3rd October 2024, filed by the filed on behalf of the petitioner is taken on. Next paragraph. Petitioner is a retired assistant teacher who superannuated on 30th June 2016. Stop. After superannuation of the petitioner, comma, first pension payment order was issued on 17th January 2019. And as per the first pension payment order, disbursement of literal dues was made in favor of the petitioner. Stop. Subsequently, due to revision of pay as per ROPA 2019, the revised pension payment order was issued on 16th September 2020. Stop. Petitioner claims interest on revised gratuity as per revised pension payment order due to delayed payment. Next paragraph. Accordingly, comma, the director of state respondents are darkar. Accordingly, comma, the director right. Accordingly, the director of pension provident fund and group insurance and the concerned treasury officer are directed to pay interest at a rate of 8% per annum to the petitioner on revised gratuity as per revised pension payment order from 14th February 2020 till the date of actual disbursement of revised gratuity amount in favor of the petitioner, comma, within a period of 8 weeks from the date of communication of this order. Stop. তারপরে তিনটে usual paragraph disposed of.
Grateful.
Item number 68.
Both the state respondent, my lord, kindly excuse me, my lord. In spite of direction, I could not affirm the affidavit on behalf of the Commissioner of School Education. Though issue has already been settled, the ESI authority, my lord, illegally stopped the, my lord, bank account of the school. Subsequently, by intervention, this honorable court was passed an order of stay. Accordingly, matter was settled. My lord, account was open. School is running smoothly. In spite of that earlier direction, there was in terms of the earlier order, my
Past usual order says the petitioner is not represented.
yes, though my duty is, I could not affirm. That is why.
Issue. At the time of call, no one appears for the petitioners and no accommodation is paid for. However, state respondents are represented by learned advocate. Next paragraph. Writ petition stands dismissed for default. No cost urgent xerox service copy. There shall be no orders to cost urgent xerox service copy. Next.
Item number 69.
I'm for the petitioner.
Hearing matter.
Relating to interest and gratuity as well as arrear pension arising out of pay protection measure. Arising out of pay protection.
Who is appearing for the state?
Well, Mr. Sujit Gupta appearing. Milord, yesterday I personally went to his chamber and requested him.
Whether the issue can be decided in absence of the state.
Well, this is a very short matter. Kindly fix the another date. I have no problem. Arising out of my pay protection, Milord. Husband of the petitioner number 1, filed 2 writ petition, 1 condemned. Thereafter, he has come before Lordship. The order was passed on 22nd February 2022. Though the husband of the petitioner retired from the post of assistant teacher in the year of 2002 and revised pension payment order
You are claiming interest on gratuity as well as revised pension, as well as arrear pension.
Arising out of pay protection.
I couldn't follow. Arising out of pay protection.
Pay protection, Milord, there was a dispute with regard to scale, Milord. When the petitioner retired in the year 2002,
Place the case.
Milord, list of dates, Milord.
Who are you? Who are the?
I am the legal heir.
You are the heirs of the deceased teacher. Your mother was a teacher.
No, Milord.
Father.
No, petitioner number 1 is the widow. Widow.
Who was the teacher?
Husband. Husband of the petitioner number 1.
There was only one petitioner.
One. No, Milord. Petitioner in respect of WTA number 11,811. Pirinchi Kumar Ghosh. He was the sole petitioner.
He was a teacher.
He was.
He was a
Thereafter,
teacher.
He died in the year 2024. And the legal heir has come before your.
Who are the legal heirs? Wife and
wife,
sons and
2
daughters.
sons and 1 daughter.
Now they are claiming interest on gratuity and arrear pension.
Arrear pension.
Why?
Milord. Milord, kindly come to Milord. First pension payment order. It's not really legible copy, Milord.
Yes, it is at page 11. 22nd August 2022.
22.
Yes,
Milord, that is the revised PPO. First PPO, Milord, there is not legible copy. That's why I have not annexed. Revised pursuant to direction of the Honorable Court. Milord, the Commissioner of School Education has released the overdrawn amount which was deducted from his gratuity. That is amounting to rupees 1,06,000 something, Milord. Milord, kindly come to the passed by my Lord Justice Krishna Rao.
Pension with effect from 1st November 2002. 1st November 2002 pension. Therefore, you retired on 30th October 2002. Petitioner teacher retired on 30th October 2002. Thereafter, what happened?
Thereafter, Milord, pension payment order was issued 23rd October 2002. And there
Where is that pension payment order?
First pension payment order.
It is not annexed to this.
Milord, it is not legible. And Millard, kindly come to the middle portion amount, 1,06,832. That was deducted as a overdrawn.
882.
Yes.
30, not 32.
My lord.
Yes, that was
from-
deducted.
Deducted from his gratuity.
Yes, subsequently that has been paid.
My lord.
Then
on the basis of the order, my lord, on the basis of the order passed by my lord Justice Krishna Rao on 25th February 2022.
yes, you are entitled to get the benefit in terms of the ratio of Rafiq Mashi.
Has been given, but no interest has been given. My lord.
What interest?
My lord, my overdrawn amount that has been released on the basis of
That
the
was that was not a delayed payment. On calculation, overdrawn amount was deducted.
Deducted. My lord.
Now thereafter, the court directed to release the overdrawn amount. It was wrongly deducted.
My lord.
Then it was paid.
Paid.
Why will get the authority will get interest?
My lord, I retired from the post in question 2002.
Maybe pension payment order was issued on 23rd October 2002. Now on calculation,
On the basis of the
on calculation, what was the basis of deducting the amount?
My lord, there is a scale dispute.
Yes.
With
Yes.
scale, higher
Yes.
scale of pay. My lord, kindly have a look to the order passed by my lord Justice Krishna Rao.
Monthly. Yes, sure. At the time of call, no one appears for the state respondents. Sure. By the present writ petition, substituted petitioners who are the heirs of deceased teacher, being the original petitioner, are praying for direction upon the state authorities to sanction interest on gratuity and that and on sum of rupees 106882, which was deducted from the gratuity of the petitioner as reflected from the first pension payment order dated 23rd October 2002 by 22nd August 2022 PPO. What was paid?
What was Malad gratuity along with ADR pension? That is reflected in the judgment page, inner page 6, Millard. The respondent number 2 is directed.
That was issued in terms of the order of the coordinate bench dated 25th February 2023.
Judgment was delivered.
Copy of the first pension payment order dated 23rd October 2002 is not part of record, but the same is placed before this court and taken on record. Stop. Original petitioner retired on superannuation on
31st October 2002.
31st October 2002. And the first pension payment order was issued on 23rd October 2002. Which is prior to, now, that means prior to the date of superannuation, first pension payment order was issued. State respondents found that rupees 106882 was excess drawn, was drawn in excess by the petitioner, by the original petitioner. Therefore, the said sum was deducted from the gratuity at the time of settling the pension, at the time of releasing the retirement dues to the petitioner, to the original petitioner. Stop. Next paragraph. The steps taken by the state respondents to adjust rupees 106,882 from the gratuity of the petitioner was questioned by the original petitioner, and the writ petition being WPA 8509 of 2016 was allowed by a coordinate bench by judgment dated 25th February 2022. Whereby the order of the Commissioner of School Education dated 17th March 2015 denying pay protection to the petitioner, to the original petitioner, was set aside, and direction was given upon the state authorities to release the excess drawn amount to release the amount of to release the sum which was in favor of the petitioner, which was deducted at the time of releasing retirement dues. However, while allowing the writ petition with a judgment dated 25th February 2022, the coordinate bench did not grant interest on alleged did not grant interest on the said sum which was deducted from the gratuity of the petitioner. And on perusal of the said judgment, it does not appear that any claim was lodged for payment of the interest. Stop. Next paragraph. After receiving the benefits, original petitioner filed the present writ petition claiming interest on gratuity and arrear pension. Stop. After superannuation of the original petitioner on 31st October 2002. Now, before superannuation of the original petitioner on 31st October 2002, first pension payment order was issued on 23rd October 2002 by the state authorities, releasing retirement dues, including pension, but a sum of rupees 106,882 was deducted from the gratuity of the petitioner, since it was decided by the authority, original petitioner, since it was decided by the authority, a state authority, that the original petitioner is not entitled to get peer protection. Stop. In this regard, an order was passed by the Commissioner of School Education on 17th March 2015, which was ultimately set aside by the coordinate bench. Next paragraph, since prior to date of superannuation, pension payment order was issued in favor of the original petitioner. And at the time of deciding the writ petition being WPA 8509 of 2016, no leave was granted to the petitioner to lodge further claim for payment of interest on the deducted on the amount which was deducted from the gratuity of the petitioner. This court is not inclined to grant interest as claimed first by the original petitioner by presenting this writ petition, and subsequently after death of the original petitioner, the substituted petitioners. Stop. It needs to be recorded that it needs to be recorded altogether. It needs to be recorded that pensionary benefits, or it needs to be recorded that retirement benefits as well as the amount which was wrongly deducted, as well as the sum which was wrongly deducted from the gratuity of the original petitioner have been released. Next paragraph. Accordingly, the writ petition stands dismissed. There shall be no orders to process. You will get back these documents after the order is signed.
My lord, may I submit one thing, my lord?
Yes, you will get it.
My lord, according to the judgment of the Honorable Division Bench, as well as Apex Court, my lord, I am entitled to get such interest.
Next matter.
I'm good.
Item number 70.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. You are for the state.
Mr. Chupriyo Chattopadhyay with Iti Dutt is appearing. There
Where is Mr. Chattopadhyay?
court room number 39. He's on his legs, my lord.
Stop. Next paragraph. Sorry. Stop. The writ petition stands dismissed for default. There shall be no orders to costs. Next.
Item number 71.
71, my lord.
Have you served upon
My
the
lord,
non-appearing respondent?
I am sorry, my lord. I have served earlier, your lordship directed to her send a notice, but
No,
that
I have
notice,
given a direction to serve notice upon the
notice,
non-appearing
non-appearing,
respondents, including
my
West
lord,
Bengal Board of Madrasa
but
Education,
my lord, that,
on 11 September 2024. Where is the service?
my lord, that has not been done in the file, my lord. I'm sorry, my lord.
Issue. At the time of call, learned advocate representing the petitioners has prayed for accommodation to has prayed for extension of time to serve notice upon the non-appearing respondents in terms of the order dated 11 September 2024. Stop. However, state respondents are represented by learned advocates. Next paragraph. List the matter under the same heading in the monthly combined list of January 2024 in order to enable the learned advocate for the petitioners to complete in order to enable the learned advocates advocate representing the petitioners to take steps in terms of the order dated 11 September 2024.
Also January 2025, I think.
2025. January 2025.
Item number 72.
Your Lordship, I have got the petitioner.
And I am
But
for
on
the state.
29th August, your Lordship was pleased to direct me to serve notice as well as order to the non-appearing respondents. That is why I have affidavit service, I have served by speed post, and track report is also annexed.
Yes.
My respectful submission of your Lordship, page number 55. The order dated 12 February 2015. Against that order, I have come before your Lordship. Page number 55. My prayer to appoint her as guest teacher. In this context, the said order is speaking those who will
Whether
complete.
the elementary education is coming under my determination. Elementary education deals with which branch of education?
Upper primary is here.
Upper primary.
Yes, up to upper primary is here.
From class 1 to upper primary.
Upper primary class 6, 7, 8. 6, 7, 8. 6, 7.
Whether it is a matter relating to appointment of guest teacher.
Guest teacher.
But the issue is decided by the Honorable Justice Mantha.
As per determination.
And this 12th February 2015 order was taken into consideration by Justice Mantha.
But
A bunch of matters were disposed of.
But initial appointment as per my instruction is this on 7th of March 1996.
No, before 93.
96.
Wrong.
The assistant, he was assistant teacher, she was appointed as a volunteer teacher, but by the managing committee. From 2007, this is the instruction is this 2nd of July 2007 to 31st of August 2022.
But what is the subject matter of challenge? Because this is a government order notification, which is at page 55. What is under challenge? What petitioner is claiming? Yes, I am asking you what petitioner is claiming. This is a government order.
Lordship, my respectful submission, I have been working since 1993.
As
more than 30 years. As assistant teacher, voluntary, etc.
Voluntary assistant teacher. Where is your appointment letter?
My Lord, PO Lordship, sit for a moment. One after another, I will place everything.
Please show me your engagement letter.
20.
Engagement letter.
29, Lordship. One after another, I will place. I am very much grateful by you. Page number 29 for a moment.
Just a minute.
Secretary of the Managing Board. 29.
এখানে লিখে দিচ্ছি
आगे दिया है
Assistant teacher voluntary appointment. So what right you have got for approval?
I am coming. That's why the order was passed. That might be ultra vires. This is my humble and respect.
No, that order need not be examined. Your basic appointment, your initial appointment is as voluntary teacher without following the procedure. So therefore, what right is accrued in your favor?
My Lord, I am coming, my Lord. Page number 30, my Lord, joining letter. Thereafter, my Lord.
Nobody is denying that you have not worked. But the question is if your initial appointment is divorce the recruitment rules, then where is your right?
Next order, next appointment, your Lordship, page number 34. One after another, my Lord. I am placing them. That is also volunteer teacher.
Show me the best document which you are relying upon in order to protect the service of your client.
My respectful submission on that basis, school authority, page number 30, school took a resolution. One after another, I am coming. Next page, my Lord, page number 37, my Lord. Page number 30, your Lordship, what
where is the prior permission? Where is the date of when the interview was held? Where is the approval memo by the DI for your appointment?
In this case,
Whether by following the recruitment rules,
she was deprived. This is a respectful submission. So, your Lordship, my Lord, before passing order, my respectful submission, my Lord. My Lord, your Lordship, hear the matter. Thereafter, your Lordship pass this order. It is my humble and respectful submission. My Lord, page number 47, my Lord. My Lord, your Lordship, see.
By presenting the affidavit service filed on behalf of the petitioner is taken on record. Stop. Next paragraph, by presenting this petition, petitioner has prayed for. Petitioner has virtually has virtually prayed, petitioner has virtually prayed for approval of her appointment as an assistant teacher in Gulbagh Junior High Madrasa, District Howrah. Stop. In support of the case made out in this writ petition, attention of this court has been drawn to the appointment letter dated 23rd April 1993, issued by the secretary of the aforesaid school. Stop. Petitioner prays for. No, stop. The learned advocate representing the petitioner submits that petitioner has been working as assistant teacher in the aforesaid school for a long period of time,
More than 30 years, Lordship.
which requires consideration for issuing mandamus, directing the state respondents to sanction the post where petitioner is presently working and accord approval of appointment. Next paragraph. State respondents are represented by learned advocate who has opposed this writ petition on the ground that initial appointment of the petitioner was dehorsed the recruitment rules. Therefore, no right accrues in her favor. Next paragraph. Having considered the respective submissions made
There
on
a
behalf
para
of the-
teacher was appointment. Was
made on
issued
behalf
by-
of the petitioner, made on behalf of the parties,
Page number
and
47.
taking note of the materials available on record, it appears that petitioner's initial appointment was not in accordance with the recruitment rules which were in vogue at the time of which were in vogue. Stop. Petitioners, stop. Nothing has been shown before this court that the post against which petitioner
For a moment, madam.
petitioner was appointed was approved post, and prior permission was issued by the concerned district inspector of schools, within bracket AC, for initiating selection process to fill up the said post. Stop. It transpires that no enforceable right has been accrued in favor of the petitioner based on her appointment, vide appointment letter dated 23rd April 1993, warranting issuance of mandamus in order to protect
Only
the
for a moment.
service of the petition.
For a moment, my lord. You Lord shall see for a
In this
moment.
regard, reliance is placed on the judgment of the Honorable Supreme Court, reported in 2006, Volume 4, 1 SCC. Excise superintendent না তোমার সাইটেশনটা দেখে নিও উমা দেবী 3. Stop. Next paragraph. This court stop. Accordingly, the writ petition stands dismissed. There shall be no orders to close.
Page number 47 for a moment, my lord. Your lordship will see. Thereafter, your lordship, my respectful submission, my lord. In
Next.
para teacher, my lord.
Next matter.
I was appointed.
Item number 73.
My lord, item number 73 and 74, my lord. Mr. Sheikh Shahjahan Ali, he couldn't appear before this court, my lord, because he is very much ill, as per instruction from his clerk, my lord. But kindly, my lord, not today, my lord.
He's an advocate on record.
Advocate on record? My lord, yes, my lord. Yes.
What has happened to him?
My lord, he is saying that gastrointestinal problems.
But last occasion, one K.C. Das appeared. He is also ill.
My lord, he was senior, my.
Yes, where is he? Go for the state. At the time of call, accommodation has been paid for on behalf of the petitioner. Since the learned advocate for the petitioner is not well or is unwell. Stop. Next paragraph, state respondents are represented by learned advocate. Next paragraph, list the matter under the heading motion in the monthly combined list of December 2020. Next.
Item number 74.
That for the state trust.
Same.
My lord, 74 is same.
Same advocate, Shahjahan Ali. Same order.
But Lordship, earlier occasion, Lordship directed the Lord to serve the copy of the respondent.
Just to solve it. Yes, that I've seen. Since the learned advocate is unwell, that's why I'm adjourning the matter. Higher scale of pay matters later.
But he is eligible.
But at the time of appointment, he was undergoing course. I've seen this.
Part one, Lordship already, Lordship, so both.
So there was a division main judgment will happen.
It was Lordship judgment. Same order.
Item number 75.
Matter, Mr. Pujit Chatterjee is appearing.
Hey, Subhendra, এক মিনিট। ওই যে সাইটেশনটা বললাম না 2006
In this matter, Mr. Pujit Chatterjee is appearing. Today, my lord, the elder sister-in-law was expired.
So,
Your lordship, thank you.
So you are for the state.
I am for the mission.
Mission. At the time of call, accommodation has been paid for on behalf of the petitioner since learned advocate for the petitioner is not present in court due to personal difficulty. Next paragraph, however, state respondents and Paschim Bongo Rajya Shishu Shiksha Mission are represented by learned advocates. Next paragraph, list the matter under the heading motion in the monthly combined list of December 2020.
Good.
Next.
Item number 76.
I appeared on behalf of the petitioners. Milord, on the last two occasions rather, there was a direction upon the commission to file a report, Milord.
Just a minute.
ER after that, ER.
Yes.
I've affirmed it today, so I've just handed over a copy.
I just received a copy, Milord. I would seek a leave to file an exception if necessary.
Which paragraphs?
Paragraph 4E and F, that is page 4.
E and F.
E and F, yes. Judgment টা বার করো তো। যেখানে upper primary final judgment.
So as per E-mark sheet score, petitioner is not eligible.
No.
If petitioner did not come within the zone of
Yes,
consideration.
yes.
Paragraph
F is the
Initially 233 candidates, including the petitioners, were removed because there was a mismatching of marks.
yes.
Now, to that extent, leave was granted by the Honorable Division Bench. Subsequently, the Honorable Division Bench, while disposing of the appeal, directed the Commission to follow E-mark sheet.
Yes, instead of looking at the different mismatches, either with the server or with the OMR or whatever, court said you go strictly on the basis of the E-mark sheets.
To go by E-mark sheets.
Yes.
Now, E-mark sheets in connection with TATE.
Yes, yes.
TATE. Now, if E-mark sheet score is taken into consideration, then how petitioner did not come within the zone of consideration?
His marks were lesser than the last candidate.
Indicated this in your affidavit.
No, that particular I have written in paragraph F, the petitioner was rejected due to restoration of his E-mark
Yes,
sheet
but
score.
some more paragraphs are
one line more should have. Could
this affidavit is not exhaustive. Very well, E-mark sheet accepted.
Yes.
That was in terms of the order of the Honorable
Yes,
Division Bench.
yes.
But what was the marks of the petitioner and what was the
No,
cut-off marks?
that I have not indicated. That marks.
Take it back, file afresh.
Very well. Very well.
No supplementary evidence.
No, no.
It's not exhaustive.
Very well.
You have not checked it up.
No, I have checked it. I could not actually procure it.
Because E-mark sheet, very well. But even if E-mark sheets are taken into consideration, why petitioner was not considered?
Yes,
so there is a further stage.
Statistics I have not given.
That needs to be highlighted in
Very
the
well,
affidavit.
I will put it in. 1 week's time, I'll put it in.
And if I draw your lordship's attention to page 30.
Your turn will come later. Let an affidavit, a proper affidavit be filed, so that if it is necessary, you would be permitted to extend to respond. Otherwise, not. Take it back. Yes. I'm not recording this.
Very well.
At the time of call, learned advocate, at the time of call, Dr. Patro, learned advocate representing West Bengal Central School Service Commission, has prayed for extension of time and has filed an affidavit pursuant to the order dated 29th August 2024. Has filed a report in the form of affidavit. Stop. On perusal of the said affidavit, said report, it appears that the same is not exhaustive. Stop. The learned advocate for the commission has prayed leave to withdraw the said affidavit and has also prayed for further leave to file fresh affidavit. Next paragraph. Acceding to the request made on behalf of the commission, time to file report stands extended for 10 days. Stop. List the matter under the same heading No, for 10 days, stop. For 10 days, stop. Copy of the report in the form of affidavit shall be served upon the learned advocate representing the petitioner. Stop. On receipt of the said report in the form of affidavit, leave is granted to the petitioner to file an exception to the said report by 10 days thereafter. Next paragraph, list the matter under the same heading in the monthly combined list of December 2024. He will definitely pray for opportunity to respond to the report. So let this procedure be made complete.
Item number 77.
Not a back to appear for the petitioner. For the respondent number 3 were to file a report, my lord.
Yes.
The respondent number 3 was to file a report.
Yes.
The petitioner is praying for retirement benefits as per ROPA 9 to the
Order process. Who's for the state? Where is the report?
Instruction, but I have not given.
Yes, there is a direction by the coordinate bench on 25th April 2024. Directed to file a report on the said grievance of the petitioner. Why this pension of the petitioner has not been fixed in terms of ROPA 2019? File a report. File a report. Now, why this benefits under ROPA 2019 has not been have not been given?
Before his retirement, while preparing the pension papers, his school authority found certain anomalies regarding his drawing of each end. It was detected that some overdraft, in spite of immediate request, the petitioner did not submit requisite documents regarding his spouse. Under the law, we are supposed to submit those documents.
He has received pension otherwise.
Yes, my lord, as per ROPA.
Only it is a case of consolidation of pension in terms of ROPA 2019.
Yes. For 2019,
exchange your affidavits.
He has to comply certain formality. School authority
Exchange your affidavits.
Only the date of retirement.
Because you have received pension. Only you are claiming consolidation of pension in terms of ROPA 2019.
Effect of ROPA 2019.
Yes.
Because, my lord,
let it be decided on exchange of affidavits.
ROPA 2019 is applicable from 1
when petitioner has retired.
34/29.
When petitioner has retired.
30th April 2019. And effect has been given, my lord, from 1/1.
Why the writ petition has been filed in 2023?
This is second round of litigation, my lord. Pursuant to the direction of the Honorable Court, PPO was issued. PPO was issued, my lord, on.
Where is the PPO?
Page 32. January 2021, the PPO was issued. Pursuant to the recent order dated 16 December 2020, I have challenged the recent order in another writ petition.
Matter relates to sanctioning of pensionary benefits in terms of ROPA, in terms of revision of pay and allowance rules, revision of pay and allowance rules 2019. Stop. The learned advocate representing the petitioner submits that petitioner retired on superannuation on 30th April 2019 and subsequently pension payment order was issued on 19th January 2021. But the grievance of the petitioner is, while releasing retirement dues, instead of applying, while releasing retirement dues, claim of the petitioner under ROPA 2019 has been denied. Stop. Next paragraph. However, from the submissions made from the learned advocates representing the petitioner and state respondents, it appears that petitioner is in receipt of pension in terms of pension payment order dated 19 January 2021. Stop. Question which needs to be decided, the issue which needs to be decided, whether petitioner is entitled to receive benefits, whether the petitioner is entitled to get the benefit of consolidation of pension, whether petitioner is entitled to get the benefit of consolidation of pension in terms of ROPA 2019 or not. Next paragraph. Issue needs to be decided on exchange of affidavits. Stop. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 1 week thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for expeditious hearing after the time fixed herein above for exchanging affidavits. Apart from state respondents, other respondents are there. Stop. The learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file affidavit of service on the next date.
I have instruction that he is entitled, but if he did not comply certain formalities, the school authority was unable to process these papers in terms of about 2019. School authority wrote a letter to the teacher concerned, but he did not respond. That's why.
Very well. Put it on affidavit. Yes.
Item number 78.
I am for the petitioner, my lord. My lord, kindly is on page 28, my lord.
It's the matter of the head. Another one. Stop. Yes.
Kindly see page 28, my lord.
Oh, that matter.
Yes, my lord. Actually, I
completely misled this court.
Well, I'm
Court
sorry.
passed an order.
I'm
Court had
extremely
to
sorry.
recall this order.
I'm extremely sorry, my
And then simply court had to adjourn the matter.
Extremely sorry. I took instruction from my client, lord. He is getting postgraduate scale. Only my grievance is, my lord. Did I give the
Who is for the state?
Supriya Chattopadhyay. He was
Where is
last.
Mr. Chattopadhyay and Joy Maiti?
Today I have not seen him, lord.
Yes. What is the
Only
matter?
my prayer, my lord, in the approval memo issued by the DI, my lord, my scale of pay would be, my lord, level 15, not 11. My approval, it has been mentioned as 11 pay scale, but it should be.
Which approval?
Actually, my lord, I have been transferred from Kuchbiar to Purva Bardhaman.
You have been transferred or you will be transferred?
No, I have only transferred, my lord. I have joined 2022, my lord.
Yes.
2022, I have transferred, my lord, from Kuchbiar to Purva Bardhaman. The TI Purva Bardhaman issued approval. In the approval memo, it has been mentioned scale
approval for what? For transfer, no approval is
required.
required.
Yes, man. Kindly see, my lord, my lord, kindly see page, my lord, page 24, my lord. Page 24. Fifth column, scale of pay as per RUPA 2019, level 11.
Just a minute.
Page 24 and P5, my lord. And page 27.
Just a minute. Why there is a necessity to approve the appointment? Because it is not a fresh appointment, only a transfer from one school to another school.
Now under the district of through about the previously Kuchbihar.
When you join the new school on transfer,
15th of September 2022, my lord.
5th August 2022.
Please, my lord. If you lordship kindly see, my lord, page number 27, my lord, the previous madrasa, last page certificate, page 27, my lord. There is also mentioned, my lord, level 15, my lord. My lord, column 4, my lord, pay level 15. Is my last page certificate issued by the previous madrasa, my lord. Only that, I am getting my master discipline, postgraduate scale, my lord. Only that, my lord.
I am asking when you have joined the present school.
On the 5th of August 2022, my lord.
Where from you are getting?
With the approval memo, my lord.
Apart from approval memo, where is the joining letter?
My lord, page my lord 22, my lord, present madrasa issued my lord appointment letter, page 22, my lord.
But it says theology pass. Page 22.
22, my lord, actually.
Theology pass.
My lord, for higher scale of pay, previously I, my lord, moved before the High Court, pursuant to order of the court, my lord, I am getting postgraduate scale, my lord.
From which date you are getting this higher scale, postgraduate scale? From 23rd June 2001.
That's with effect from 23rd June 2001.
What is the date of your initial appointment in the first school?
Initial appointment, that is, my lord, I was getting my postgraduate scale. I was
When you were appointed initially?
appointed, my lord, 2001, my lord.
Have you annexed the order of the Honorable Court? Whereby direction was given by the coordinate bench to grant postgraduate scale of pay in your favor?
On that I have not annexed, my lord, but my lord,
Where is that order?
then my lord, tomorrow kindly, my lord, tomorrow I shall bring that. My lord, if you lost kindly page.
Show me the order of the honorable court.
If you kindly page 21, my lord, for 21.
Page 21, I am on page 21, that's why I'm asking you.
My lord, today my order is not with me.
Issue. At the time, the matter is heard in presence of the learned advocate representing the petitioner. Stop. Next paragraph, since postgraduate scale of pay has been granted to the petitioner with effect from 23rd June 2001, as it appears from a document at page 21 of the writ petition, this court desires to consider the previous order of the Honorable Court dated 27th August 2018, which is not part of record. Stop. The learned advocate, next paragraph. The learned advocate for the petitioner prays for accommodation to produce the order dated 27th August 2018. On the next date, next paragraph. Today, today state respondents are not represented. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 7 days from date. Next paragraph lists the matter under the same heading in the monthly combined list of December 2024. Next monthly list.
Item number 79.
My lord, I am the petitioner, my lord.
My lord, I appear on behalf of the state, my lord.
My lord, petitioner joined in the assistant teacher of the school on first.
Just you.
Achha.
Yes.
My lord, only area pension, my lord. Petitioner joined in the assistant teacher of the school on the 1st January 1971.
But already pension payment orders have been issued.
Yes.
First pension payment order is dated 30th April 2015.
Yes.
And subsequently on 3rd March 2000, there is a second 30th April 2015 is the second pension payment order.
Yes.
And the first pension payment order is dated 3rd March 2008.
Petitioner retired on 2006, February 2006. First payment for PPO 2008.
Where is that PPO?
First PPO, kindly see. On page 23, my lord. Page 23.
There is a second PPO. First PPO page 24.
24, my lord. 24.
24 to 9.
24, my lord.
But no pension was sanctioned to you.
Now, pension started from 22nd October 2014, my lord. Petitioner retired from 2006. Our pension started on 2014, my lord.
Why?
Petitioner entitled to area pension due to 8
No,
years.
why pension started from 20? If petitioner retired in 2006,
2006.
then why pension started from 2016? 14.
2014.
Why?
Don't know, my lord. 8 years delay, my lord. 8 years, 7 months, 25 days. Delay.
Why? Yes.
My lord, kindly turns to paragraph 9, my lord. There is
Whether it is a case of switching over from CP.
Yes, my lord. My lord, kindly turns to paragraph 9, my lord. He has averred there that the petitioner states that in terms of the judgment of the Honorable Larger Bench, the government has issued a notification inviting employees to accept for pension cum gratuity.
With those case.
Yes, yes. My lord.
Paragraph,
My lord, paragraph 9, page number 8 of his writ petition, my lord.
just it.
So, my lord, he had switched over from that CPF to GPF scheme, my lord. But this has been missed.
Now you want the arrear pension from
Exactly.
the date following the date of superannuation
Yes, yes.
till the date of refund.
Yes, my
Refund.
lord.
My lord, that
Kindly
is his
proceed
first
to
prayer.
Prayer B, my lord. Kindly see prayer B, page 17, my lord. Issue the
What is the
legal-
date of your retirement?
My lord, 29th February 2006, my lord.
2006.
My lord, there is a
Retirement
mistake
of
in
petitioner
numbering of the
29
paragraphs, my lord.
38 April 2015. the
28th
disbursement-
February 2006.
Yes, yes, my lord.
Yes.
28th February 2006. And he wants the calculation commencing from the 29th of February 2006.
So retired on 28th February 2006.
Yes.
my lord.
And pension started on 22nd October 2014.
My lord, turn
8 years delay, my lord. 8 years, 7 months, 25 days.
না ফার্স্ট অর্ডারটা 2008 এ এসেছিল
না না কিন্তু আমাকে স্টার্ট করে পেনশন স্টার্ট করতে তো
সেটা তো
2014
হয়েছে সেটা 14 স্টার্ট করেছে তারই তো এরিয়াসটা চেয়েছে না
হ্যাঁ সেটাই তো চেয়েছি আমি ওইটুকুন যথেষ্ট
এর সুইচিং ওভারের একটা অর্ডার দেখো তো।
নাম্বারিং ঠিক করে করেননি এখানে দেখুন 1 2 3 4 5 6 7 8 9 10 আবার দেখুন 9 আবার 10
কিছু হুম You are an assistant teacher
Yes,
or
my lord.
non-teaching staff?
assistant teacher.
Within 12 weeks, issue revised pension payment order for releasing the
Yes.
arrear pension.
Yes, my lord.
Yes.
Disposed of.
Yes.
I'm grateful, my lord.
এইখানে না ভুল করেছে একটু। এইটা ঠিক আছে 13 জুন 2014 টা থাকবে পরেরটা রিজনাল রাইট যে পরেরটাতে 30th এপ্রিল 2015 হবে পেনশন পেমেন্ট অর্ডারের ডেটটা এটা ঠিক আছে এটা ঠিক আছে পরেরটা কেটে 30th এপ্রিল 2015 পেনশন পেমেন্ট ওটুকু
I'm grateful. Item number 80.
Item number 80. On behalf of the petitioner, my lord, on the last occasion, the 7 except Central School Service Commission, nobody appeared. So my lord was pleased to direct me, my lord, to serve once again upon the private respondent as also, my lord, upon the, my lord, the others non-appearing respondents. My lord, I have served, but this letter was sent in the last week, and yesterday all of a sudden was declared holiday. That is why, my lord, no track report is available. My lord, would it be possible for your
holiday means yesterday?
Holiday for the
government offices?
Yes. GP office also will not remain closed. Today, will not, we are facing difficulty because one of my public interest litigation is fixed on 7th. And today I was,
service is not complete.
We have sent, but until and unless I can get, let it appear on Friday. I hope I will.
At the time of call, learned advocate representing the petitioner has prayed for accommodation to complete service of notice upon the non-appearing response in terms of the order dated 24th September 2024. Stop. Here for the commission. However, West Bengal Central School Service Commission is represented by learned advocates. Next paragraph. List the matter under the heading motion in the monthly combined list of December 2024 in order to enable the learned advocate for the petitioner to complete service of notice upon the non-appearing respondents. And to file affidavit of service. Next.
Item number 81.
Lordship, I am for the petitioner. Lordship, on the last occasion, there was a direction upon the learned advocate to serve a notice upon the non-appearing respondent. Lordship, the client is not well, Lordship. There is no such instruction from client. He could not turn up. I am praying for 2 weeks time, Lordship. I will come back with
That means client is not interested.
Lordship, I will come back with proper instruction, Lordship.
No. 24th September 2024 order was passed.
Lordship, I have informed actually.
How long this will continue?
Lordship, actually, he is not well. I've been instructed to take some time, Lordship.
What is the matter about?
Lordship,
these things cannot continue for an indefinite period.
Lordship, kindly keep it after 15 days,
Sorry.
Lordship. Kindly.
41 years old client is not well, nobody will believe it. Yes, what you are praying for?
Lordship, I am not in this matter.
Same self matter. Yes, who are you?
Lordship,
Who is the petitioner?
Lordship, Abdul Rahim, Lordship, Mrs. Songita Roy.
How he is related to the madrasa?
Lordship, I am not aware of this. I've been only instructed to take time.
Yes.
Lordship, another
Peculiar prayer
Another
that a royalty land is required to be accepted by the madrasa authority by a deed of gift, and on that land a construction of the school building has to be made.
And your lordship, on same character nature, another matter was filed in the year 20.
I'm not concerned. First, let me consider this matter. When another matter will come, I will consider this.
Lordship, the same
Yes. Who are you? You are only instructed by the learned advocate to take time.
Lordship.
Yes. So how do you know that the petitioner is not well? You are just submitting
We have been instructed.
few minutes back that the
Lordship,
petitioner is not well. If you are if you are nobody and you are requested by the learned advocate representing the petitioner, then how do you know that the petitioner is not well?
Lordship, I have that instruction only to that petitioner is not well.
What has happened to him?
Lordship, I am not aware with only there is no such instruction. Petitioner is not well. He could not turn up. Only 2 weeks time, Lordship.
Issue. At the time of call, accommodation has been prayed for on behalf of the petitioners. Stop. However, on perusal of the order dated 24th September 2024, it appears that the learned advocate for the petitioners was directed to serve notice upon the non-appearing respondents. Within a specified time. Stop. Matter was directed to appear in the list under the heading motion. Matter was directed to appear in the combined monthly list of November 2024 under the heading motion. Stop. Next paragraph. It appears no steps have been taken in terms of the previous order dated 24th September 2024. Stop. Today, you are Madrasa Service Commission, West Bengal Board of Madrasa Education. Today, West Bengal Board of Madrasa Education is only represented. Next paragraph. It appears that petitioners have lost interest. Stop. The writ petition stands dismissed. However, there shall be no orders to cost urgent submit. Next.
Item number 82.
I am waiting for the
But I have to state this one.
देखिए पूछिए petition to
Service
Lordship,
upon the non-appearing respondents.
Lordship, it is not with me. I have informed.
Yes.
My advocate on record informed.
Why you have not served?
Lordship,
yes.
is not served by the learned advocate on record, Lordship.
Why?
I don't know. He corrected and he told me that I have informed all
Who are the respondents today
Right,
represented?
appear on behalf of the West Bengal Council of Higher Secondary
You are
Education.
for the
All
West
the-
Bengal Council of Higher Secondary Education.
Lordship, my lord. With a reassessment, evaluation of the answer script, my lord, very recently, Honorable Division Bench, my lord, my lord, passed this judgment, my lord, considering all the judgments of Supreme Court, Apex Court and other.
Also, twofold prayer is that he sought for his paper of mathematics and the respondent.
Yes, please, okay.
Well, this is
submitted only
very recently this judgment.
Judgment will come later.
Lordship.
This is not your petition.
Lordship, my lord.
3 loose sheet, but out of 6 loose sheet, 3 loose sheet was not supplied to me. Petitioner's prayer is that to supply the rest 3 loose sheet of the mathematics subject and as well as the face evaluation of the English paper.
Yes, in connection with which, place the facts, please place the facts in which examination?
It is 22 in the year 22.
In which exam? Class 1 examination?
No, high
Then?
secondary examination. And I did not get the marks well in the mathematics and English subject.
Where is the mark sheet?
Lordship, mark sheet is not annexed. I have made application before the.
Why you have not annexed the mark sheet?
It was not
In order to assess your performance in other subjects, mark sheet is necessary.
If directed, I will.
You have to satisfy the conscience of the court first in this kind of matters, for which mark sheet is necessary.
Lordship.
So that you can demonstrate a case, demonstrate that in mathematics only petitioner has received lesser marks, but in other
Mathematics
subjects
only, but
he or she has performed well. That can be done only by replacing reliance on mark sheet. Where is your mark sheet?
Lordship, it was not with me. Lordship, kindly give me time. I will.
How you are preparing this writ petition? Withdraw the same and file afresh. This is a writ petition of 2023. What is the use of keeping this writ petition pending?
Kindly give me supplementary direction of supplementary writ. I will.
Last occasion when this matter was called on, you could have made a prayer for filing a supplementary affidavit.
It was not. I am not appeared on that date, but it should be prayed before your lordship. They have supplied me the mathematics papers and English papers, but in the mathematics papers, 6 loose sheet was taken by me at the time of examination, but only 3 loose sheet has been submitted.
Is there any defect in the scrutiny?
Lordship,
Assessment court will not, cannot.
Lordship,
Because court is not expert in the subject.
Lordship, I
Any,
have got
any defect in the
through
scrutiny?
Right to Information Act, I have got mark sheets, answer scripts of mathematics, but 3 loose sheet was not given to me out of 6.
It's a only completely a
So
factual consideration.
so I cannot-
How the read court can decide it? You file a suit.
Lordship, kindly direct them to supply me the rest 3 loose sheet.
How it is possible? They have supplied the entire answer script.
It is not
Now today, if you say that the loose sheets are not supplied, they will say there were no loose sheets.
But
How
it-
the read court can come to a finding
Lordship,
on
kindly-
this factual
kindly
aspect?
Come to the page number 13. There are stated that 111.
That's why
111.
your mark sheet is very much necessary. You have obtained 35 in mathematics. In higher secondary examination, it is out of 100 to 200.
No, 100.
100 out of 100.
Out of 100.
Now it is 100.
100.
So 35 in 100. What about your performance in other subjects?
Lordship, kindly give me one opportunity to file the
They will pay the
supplementary-
cost of rupees 10,000 for 10 days adjournment.
It is a student, Lordship.
Maybe
Lordship,
others
kindly-
are also coming for in search of employment,
Lordship, kindly consider.
and it's a luxury petition,
Lordship, kindly
completely a luxury petition.
Lordship, kindly
What
consider-
case you have made out, Mr. Chakraborty?
I'm Bhattacharya, Lordship.
Mr. Bhattacharya, what case you have made out?
Lordship, it was.
You are saying
It
that
drafted-
first your grievance was that the mathematics answer script is required to supplied to you.
Lordship,
Mathematics answer script is supplied to you.
Lordship,
Now you are saying that there are certain loose sheets which are not attached to this answer script.
Lordship,
Who will
kindly
decide
please-
it? Read court will decide it. On what basis? On what basis read court will decide it?
Lordship, they can.
It's a factual consideration.
Will supply or
You will ask your learned, you just ask your learned friend representing the council whether the council is accepting that yes, there were other loose sheets.
At the time of collecting the
Collecting the answer script, whether you have raised this dispute.
His signature in presence of his
Lordship,
guardian.
there are. Lordship, kindly see.
Yes,
there are
yes,
written in
that is
there.
also a
It will raise
very
any objection.
relevant consideration. Petitioner went there, he accepted the mark sheet, answer script,
And put his
while
signature.
accepting the answer script, he should have checked it up whether the entire answer script is there or not. On putting signature, he has received it, and now he is saying that there are other answers. Tell your client to read properly so that he can fare well in other examinations, in future examinations, instead of pursuing a case before this court.
If possible, Lordship, kindly direct them to consider.
First of all, you have received your own the answer script. You are not a student of class 5. You have passed class 12 examinations. So you are major. Now, while receiving the answer scripts, you have not raised any dispute. Now, in answer script, there is no discrepancy. Now you are saying that there are 3 loose sheets. These are not tagged to the supplied answer scripts. Who will believe it, and how the read court will decide it? What is the percentage of what is the percentage of the petitioner? So far, his performance in the higher secondary examination?
50%.
50%. So he can obtain 35 in mathematics. Pass marks. So there is no defect in the scrutiny.
Maybe, Lordship, I have not taken up that because I am not the authority to say all these things that the mathematics question answer is correct or not.
Yes, which order you are relying upon?
Good. There's a division bench judgment, my lord. 23rd September 2024.
বললাম তো আমি তো দেখালাম বলছি
টাইমটা নিয়ে দাও টাইম না আমি জানি ও টাইম দিয়ে দিয়েছে এখনই কি হবে পরে সমস্যা We'll come back tomorrow. Later. The division bench order. Let it remain in the.